Contempt application.
Can we find automatically? Contempt application গুলো তো automatically find হবে না, লিস্টে আছে। Contempt will automatically come. I have stopped mentioning for a few days.
My lord may recall that I mentioned this.
Yesterday I mentioned the
Please do not. Yes, it will. If you have mentioned yesterday, it will come in the list. Don't worry.
RD has not written matter. RD was not written matter.
Only give the WPA number. That's all.
My lord, one extension of interim order mentioned on Friday. My lord had allowed that mentioning, my lord. Somehow, my lord, matter is not appearing in the list. Again, my lord, upon notice, I'm mentioning, miss.
I will not take any further mentioning from today onwards until further order.
My lord, on Friday, my lord, this matter was mentioned. Didi,
এটা মেনশন করেছিলেন উনি ফ্রাইডেতে ফর এক্সটেনশন, একটু দেখে নিন কেন আসেনি লিস্টে।
এটা আবার
নাম্বারটা দেখে নিন।
I had mentioned earlier. Your lordship mentioned, and it was appeared in the
Try. When is the interim order expiring?
29th of February.
Please wait for some.
I'm praying for.
My lord, my Larry Junior, he has mentioned this matter yesterday, and my lord has directed him to serve a notice on the other side.
Yes, but I have taken a subsequent decision that I am sitting with about 900 matters, sir.
My lord.
If I mention, I include, and it appears as.
It is the urgency. I also, at the time of filing, my lord, I wanted to take my lord's leave. No, that I understand. That I understand.
I'm praying
at the
for
time of
leave,
filing, my lord, I wanted to take.
My lord, I'm praying for leave.
My lord, at the time of filing.
My lord, there is grave urgency in the matter, lordship. They are dispossessing. My lord,
Well, not for inclusion, only for upgradation.
When is it expiring?
No, 29th is expiring. I am requesting your lordship.
So please come after some days.
my lord, the national.
Well, only for upgradation, my lord, urgency is involved.
My lord, I'm praying
at
for
the time
leave
of
for
filing,
dispensation of Rule 26, lordship. Lordship kindly considers, my lord. My lord, they are dispossessing me tomorrow, lordship. This matter be urgently heard out tomorrow morning, lordship. Anytime tomorrow morning.
Please show me the notice of disposition.
Lord, everything is ready, lordship. I will just file it today, my lord. On 21st, they will come and dispossess, and they are doing it without any demarcation of the property. My factory equipments and everything is lying over there. I have no time to move it. They were supposed to do it from tomorrow onwards. They've already started doing it. They've broken down boundary walls. I have pictures, my lord. Lord, I am
appearing for the petitioner in item number 1.
Lord, I have pictures to show that the demarcation has already begun before time. I have no other option, my lord, but to come before your lordship.
My lord was pleased to so call the.
Actually, I'm doing mentioning করছি আমি।
মামলা করে
না ধরেনি, আমার চিঠি পড়ছে।
On or after 21st?
Yes, my lord, but they've already started doing it. They've broken down my boundary walls. I have pictures to show that, my lord. That is why I'm before your lordship.
I've been paid compensation.
My lord, I have not been paid compensation, my lord. That is also. My lord, that is separate, lordship. My lord, but my lord, I am suffering great loss because my factory shed is lying there. I need some time for me to remove everything, my lord. I am not object coming in the way, my lord.
When
But if
was
the
the notice served upon
my lord,
you?
I've received it on the 9th, my lord, and they have started already.
Today is 20th.
Yes,
You
madam,
have
I've.
had enough time to shift your materials.
My lord, I was, my lord, they've already broken down on 17th onwards, lordship.
My lord, I appear for the respondent. My lord, I beg to appear on behalf of the petitioner. Lordship kindly consider the earlier direction past my man lord.
Restoration. Hey, Dada.
They have not been able to serve the alleged contemner. Who is appearing for the alleged contemner?
My lord, I am appearing for on behalf of the alleged contemner number 2.
Yes, the second alleged contemner was directed to show cause as to why rule shall not be issued.
Yes.
You are lucky today that the department has not been able to serve.
My lord, my lord, I have passed an order upon hearing. An order was communicated to him. And my lord, my finding is, the contemner's finding is, yes, he has a valid claim. Now the difficulties regarding fund is not available under this heading. I have requested the concerned DM, initially DRDO, thereafter DM, please allocate the fund or otherwise allow me to use other funds to pay him.
My lord, this is a work order of 2030.
দাদা মামলা চলছে, মেনশনিং না।
My lord. The
Where is
since
your show cause?
দ্যাট মানে ওটা দাও না,
জানি ওটা জয় সাহেব জানেন।
ওটা ওটা কিভাবে জানেন?
Can you
এর
come
দিনে
back tomorrow?
বলেছি।
Yes.
I'll just make it not today.
Then my lord,
Please see the earlier order.
then my lord, tomorrow it would be difficult, my lord, from Jalpaiguri, my lord. This order, my lord has got this order.
In earlier occasion, my lord, when this matter was taken up, I have shown this
তোমরা
order.
বলেছিলে। ও,
At that time, my lord, my learned friend.
So the contender was not represented at all.
okay. My lord, then
Okay.
kindly grant me 1 week's time then.
Now, this is an indefinite thing. As soon as fund is received,
Yes, yes,
we receive after
Uh,
20 years also.
yes, my lord, he is not at fault. Until unless if my lord directs that other fund may be diverted, he can do it. Or his superior boss has to, my lord, say that yes,
Communication to the superior.
yes, yes. I have got everything, my lord. Everything. Hmm.
It's 10 lakh 10,000, the residual amount.
Yes. Several communications been made by me. My lord, I have joined this office in October or November. Thereafter, I got to know from this.
It is submitted on behalf of the alleged contender.
Which
I have seen the report
সকালে
submitted by the department. Paragraph, it is submitted on behalf of you're the second alleged contender.
Yes,
The
yes.
second alleged contender, that the representation submitted by the petitioner, the applicant petitioner, has been disposed of in his favor. But the residual amount, this is the compensation.
no,
No,
with regard to construction work.
The residual amount of rupees 10, 10, 000, 10 lakh 10,000, could not be paid to the petitioner due to paucity of fund. Stop.
and my lord,
Second
before
alleged contender,
before referring that letter, my lord, kindly have a look also with this, my lord. This letter was to DPRDO and this first one,
who is the authority to allot?
my lord, DM, then DPRDO.
The second alleged contender has made several communications to the district panchayat and rural development officer Jalpaiguri and the district magistrate Jalpaiguri for placement of fund in order to comply with the order of this court. Stop. Such fund is yet to be placed. The paragraph, learned counsel seeks further accommodation to comply with the order under contempt in its entirety. Paragraph, let the matter appear under the same heading on how long do you require?
My learned friend will say 7 days.
হবে নাকি 7 days a fund আসবে নাকি?
1 month?
Kindly. Any indirect,
Yes, 21st March. Paragraph, it is expected that the district magistrate Jalpaiguri shall place the required fund before the second alleged contender for disbursement of the same in favor of the applicant petitioner by the adjourned date.
I'm deeply obliged. That will help me.
Please take this back and
Yes,
you
yes,
to
ma'am.
file an affidavit of compliance
Ma'am.
for the next.
Grateful.
Yes.
তুমি আছো মা?
হ্যাঁ। Deeply. My lord, I appear for the.
Lord, on behalf of the petitioner, Lord, on 5th, my lord, the matter got dismissed for default due to my lord fault. But at that time, my lord, my sister's
It's a
marriage was,
restoration application.
yes, restoration application within time. On 5th of February, my lord, this was
It's appearing. Miss-
Lord, my lord, senior, disappeared.
Are we ready with the writ petition?
Yes,
This was
matter
not
is
all
otherwise
petition.
ready for hearing.
This was item number 1, my lord, in the hearing.
Must.
Lord, it's my
hearing?
mistake.
It's a hearing matter.
Hearing matter.
CAN 3 of 2024. This is an application for restoration of the writ petition. It was dismissed for default by an order passed on 5th February 2024. Paragraph, sufficient grounds being made out, comma, the application is allowed. Paragraph, the order passed on 5th February 2024 is set aside. The writ paragraph, paragraph, the writ petition is restored to its original file and number. Can such and such is disposed of. WPA the order kurun. Let the matter appear under the heading hearing on 20th March.
I'm deeply obliged. But
Next.
Two, my lord, this is my application, my lord. This is the substitution application followed by, my lord, condition of delay, my lord. It is hearing matter, my lord, during the pendency of the application, my lord, the petitioner died.
Substitution was not made within time.
No, my lord, during corona, my lord, he is died, the petitioner died. My lord, we followed, we understand that as per the, it will cover the judgment by the Supreme Court, but it will not cover, my lord. So we filed an substitution application,
It will not cover.
not covered, my lord. So we filed another application for condition of delay.
Respondent is Hitco, my lord. Respondent is Hitco. 4, respondent number 4, we are Hitco.
Yes.
Service,
There's a deal of 345 days up to your lordship.
Where is the condonation application?
can too, my lord.
Didi, can too.
No. That's a hope.
Opposition, high.
This is a hearing matter.
Yes, my lord. This is hearing matter. When the matter is listed for hearing, we send the letter to the petitioner and we heard that the petitioner died. And we intimate that is written in the, my lord, in our condition of delay application.
I'll just take the application. Who has expired?
Petitioner, only
The sole
sole
petition.
petitioner.
Will you please hand over a copy to me?
My lord.
That's it. Okay. Then can 1 or can 2 একসাথে নেব? Third learned counsels for the parties. The applicants have paid for condonation of delay in filing the substitution application. It appears that the writ petitioner expired on 4th October 2020. Stop. The substitution application was filed on 9th March,
9th March
3
2020.
years,
2 years, my lord, covered by up to, covered by judgment of
March
Supreme Court.
2023. Paragraph, good grounds being shown, comma, the delay in filing the substitution application is condoned. Paragraph, the substitution application is allowed. Paragraph, the cause title of the writ petition be amended accordingly. Can 1 of 2023 and 2 of 2024 are disposed of accordingly. WPA the order kurun. Let the matter appear under the heading hearing on 20th March.
My lord. Deep level. I'm amending the cause title here and now.
Next.
I'm for the petitioner. Well, this is restoration application, my lord.
Have you served?
Yes. My lord, paragraph 2, my lord, I have stated.
Mr. Devroy was appearing.
Yes, my lord.
Where is your service?
এটা দিন।
Restoration. Where is he? He is in court?
Court number? One.
Restoration.
Can 3 of 2024. This is an application for restoration of the writ petition which was dismissed for default by an order passed on 5th February 2024. Paragraph, sufficient grounds being made out, comma, the application is allowed. Paragraph, the order passed on 5th February 2024 is set aside. Paragraph, the writ petition be restored to its original file and number. Can 3 of 2024 is disposed of.
My lord, matter is ready for hearing, my lord. Affidavit has been
Affidavits are exchanged. It's a group 7 hearing.
Group 1.
Group 1 hearing.
Yes.
WPA order kurun, let the matter appear under the heading hearing on 1st April.
First step. Great.
Next.
Poor Lordship, Mr.
Item number 4, my lord. I am appearing on the behalf of the petitioner. Non-appearance of the petitioner, my lord. Matter was dismissed for default. No. All right. Chinese store. Chinese store. ঠিক আছে।
Lordship, the matter is fixed for application, Lordship, but the
Already
kindly fix a
affidavit?
date. Kindly fix a date for hearing, Lordship.
I will.
Affidavit already
Let
exchanged,
it
ma'am.
be restored. Otherwise, I cannot fix a date
Yes,
for
Lordship.
hearing. isn't it?
Yes, Lordship. Kindly fix a date.
Restoration and order code. Same order. 5th February 2024.
An interim order, my lord, continue.
Yes.
Lordship, our land has been struck in this situation, Lordship. Kindly fix a short date so that hearing can be.
I'll fix a hearing date and I'll extend the interim order that was granted, right? It has been continuing for a very long time.
My last order, my lord, 12, my lord. 12 December 2023, my lord.
When was it passed, the interim order?
Interim order was passed because the Honorable Division Bench on 12 July 2021. A status quo order.
The WPA order code. Let the matter appear under the heading hearing on 3rd April.
3rd April.
Paragraph, the interim order granted earlier is extended till 30th April 2024 or until further orders, comma, whichever is earlier. Paragraph, the officer in charge, comma, Pragati Maidan Police Station, comma, being the 7th respondent herein, comma, is directed to ensure strict compliance of the interim order by both the parties. Next.
Get to the
I'm for the respondent.
This is the restoration application of the hearing stage, my lord. I could not attend, my lord, the
Hearing stage.
hearing stage. My activities are complete.
Within,
My learned friend,
within time,
within time. Within time.
let it be allowed.
Within time.
Join the
My lord.
5th February order. WPA te korun, let the matter appear under the heading hearing on 1st April.
First. কাগজ কোথায় গো কাগজ কোথায়
There are two matters, my lord, 6 and 7.
Yes.
In 6, my lord, money is not yet come, my lord.
I know.
But in 7, my lord, money has come, my lord, and we issued the notice to the petitioners, and
ask the petitioner to come.
One by
on
one, Mr. Jain,
27th.
six, let me deal with six first.
6, my lord, I pray some time, my lord. As the money has not yet come, my lord. Same,
The same order was passed on.
my lord, on the same order, but money has not come in item number 6.
How much time do you want? 1 month?
My lord, money has come, my lord, we then and there disbursed.
But the petitioner cannot wait indefinitely, isn't it? Money has to
Yes,
come.
my lord, give me some time, my lord.
Who will pay the money? Who will disburse the money?
Disburse the money from the authority, my lord, and by the DM. By
District magistrate?
On our 15th February, though I have in the order, but this notice has been
My lord, special secretary, PWD to DM. My lord, that money has not yet come to the special secretary to the PWD. Only for that is, my lord, I pray some time. তাও কয়েকটা টাকা পেয়ে যাচ্ছ তো ওটাও পেয়ে যাবে তোমার জন্য তো আমরা প্রতিদিন চেষ্টা করি কন্টেম্প হলে কি আমাদের ভালো লাগে বুঝছো না কেন?
Let there be 1 month's time in this matter.
but a notice has been to some of the petitioner. I have
The
marked the reading. Some of the 31 petitioner, but you come along with your documents such and such, nothing.
That is in the second matter, not
Second
in
matter.
this matter.
Yes, matter. Second
In
matter.
this matter, money has not been
ওটা second
received.
matter. Second matter.
Oh, yes.
Learned counsel for the alleged contemner seeks further accommodation to comply with the order under contempt and submits that the required fund is yet to be received from the district magistrate.
Yes, from the PWD, special secretary PWD. Special secretary PWD
From the special secretary PWD.
to DM, district magistrate South Chitral.
Through.
To DM. DM to PWD. To DM.
Through the
Special secretary PWD sent the money. अरे टारगेट कोता है
through the district magistrate South 24 Parganas.
Paid by that will be
secretary PWD sent the money. District magistrate the chairman of the then purchase committee. You will disburse the amount.
Try to pull
this. Yes, you disburse them.
received by the by the alleged contender from the special secretary PWD through the DM.
To the DM. Yes, my lord. Two. Send the money to DM, so the DM will disburse the money.
It will be through because special secretary to DM, DM to the contemner. So contemner will receive through the DM
Through the
from the special secretary.
Yes, my lord.
A paragraph
DM
let the
will
matter
discuss
appear
the
under the same
amount.
heading on 20th March.
20?
20th March. Paragraph, it is expected that the special secretary PWD as well as the district magistrate South 24 Parganas
Yes.
shall place the required fund before the alleged contemner before by the adjourned date. Please inform this to the incumbents.
My lord, officer has come, my lord. I have.
Otherwise, I have to call both of them in
Yes,
court on the
madam.
next date.
এই মনে থাকে জানো টাকা দিয়ে দিও নাহলে ডিএম কে আসতে বলো
Next,
next matter my lord money has already received by the DM and that will be disbursed my lord next date 27th February 2024 my lord.
No,
Notice was
out of
issued.
31 petitioners,
That
only
is
they serve notice on 6 petitioners.
Correct.
And all the petitions were directed to see along with document. And one of that, this is though I am in the red.
my lord everybody has notice issued to everybody perhaps somebody will not get that notice.
notice issued to all the 31.
Yes my lord.
No, only 6.
আরে বাবা সবাইকে দিবে
I'm sorry, Malad. I have marked with the rating. And that memo that has been, the date of the memo has been mentioned wrongly. That is 2026, 16, not 18. There's a direct purchase policy memo.
This is to 6 people. Where is the issuance on all the 31 persons?
আরে একে দিয়েছি আমাদের 15
দাঁড়াও
This was issued on 15th February. দিদি এটা ফেরত দিয়ে দিন।
my lord I must check that thing my lord whether 6 my lord all the persons
Because
Number-
there are 31 petitions.
31 petitions.
I'll keep it in the first week of February in that case.
First week of,
February,
Feb-
first week of March, sorry.
first week of March.
Yes,
Yes.
madam.
Because 27th February is the.
Yes,
date.
yes, yes, yes.
So let it appear in the first week of March. Status report submitted on behalf of the alleged
I know.
contender is taken on record. Paragraph is submitted on behalf of the alleged contender that upon receipt of the required fund, comma, notice has been issued upon all the petitioners for appearing before the concerned authority with all relevant documents for disbursal of the fund in their favor. Appear before on 27th February. With all relevant documents on 27th February 2024. Paragraph in view of the above, let the matter appear under the same heading on 5th March.
5th March, yes.
Paragraph affidavit of compliance be submitted on the agenda date.
5th March কিন্তু খেয়াল রাখবে আজকে যে কোনো
বাবা ঠিক আছে খেয়াল রাখবো যদি খেয়াল না রাখলে
Next.
দাঁড়া আমাদের একটা book।
My lord, this is my application. My lord, on 15th of January, your lordship kindly have a look at the order of your lordship's order dated 15th of January 2024.
Yes.
A report was filed. Exactly.
My lord, your lordship was pleased to direct me, my lord, to put the 7A. My lord, the money was according to the page 8, my lord, that is. Your lordship will see.
No, just now I have been handed over.
You
And
will go through
15,
this?
there was no such order that to file a report because it has been submitted that affidavit as per order dated 15 January 2020 was passed by the Honorable Justice by your lordship. But I don't find
My
there
lord,
is
your
such an order.
lordship was pleased to direct me to put the 7-2A of the proceedings of
Maybe
the
it was
same.
a verbal direction. There's nothing on
Fine,
in the order.
Madam, let me
That direction was
kindly
there, my lord,
kindly
only for
adjourn the
that
matter.
reason, my lord.
Kindly-
I filed the report
Yes.
as contempt
And
is
I will-
there, my
I will-
lord. Only for that reason I filed this report. Otherwise, my lord, my lord, if
We
your lordship.
served the copy today itself.
Yes, my
Mr.
lord.
So let it
No,
go
no,
through it and come back.
right now I have gone through it,
Yes, sir.
got it. My lord, if I kindly allow me to, if I find that there is a exception.
My lord, every day my learned friend said, if I find that there is good case, then I say nothing. But he must say something.
Yes, definitely, if I find there is something, so definitely I will say.
He knows, my lord, land law better
This is
than me,
right.
my lord. In spite of that, my lord, he want to.
That's a compliment, Mr. Pan.
This is not a compliment, my lord. This is a fact. I may not want to.
Affidavit submitted on behalf of the alleged contender is taken on record. Stop copy, learned counsel for the applicant petitioner seeks to use an exception to the affidavit, comma, if required. Paragraph, let the matter appear under the same heading on 12th March. 12th March. Next.
Lord, I am for the petitioner in this matter. Lordship, kindly have a look at your lordship's order dated 10th of January 2024. It was submitted on behalf of the contender that the appeal has been preferred.
Yes.
But till today, my lord, I have not been served with any copy of any stay application or any indication that by way of submitting a number. I don't think that they have preferred any appeal till today.
You've not even received the number of the appeal,
Not yet even.
Mr. Dev?
That your lordship. Tomorrow, my lord, because I play not today, because my lord, the appeal was prepared, and appeal was, my lord, that was good, then that my lord set aside and sent back to the SQ. That my lord, yesterday, my lord, they handed over the same, my lord, but that was not.
Appeal has been disposed of?
Yes, sir.
No.
Notice to the
No, no, my lord, what happened, if I understand, correctly, now appeal was preferred by one Mr. Suvirpal. Then appeal was dismissed as withdrawn by the division bench.
But that
Means
was
that-
not right.
Yes, before, prior to this order.
এখানকার না my lord আপনি 10-4
Huh?
এটা 850 হিমাংশু চক্রবর্তী
No, no, no.
I must say my lord what is the actual act.
This is,
Yes my lord
well, this is completely different matter, এটা অন্য matter তো।
বাবা 850
আরে 850 হাদিজান মোহাম্মদ, কি ব্রিফ নেওয়া কমাও তুমি।
আবার দাঁড়াও আমি এই যে ফুল দেখতে পাই না কি জান মোহাম্মদ ও হাজি জান মোহাম্মদ my lord that is another matter man
না, এটা জজসাহেবকে দিন।
Where are
This
the
is the,
details of the appeal?
হাজি জান মোহাম্মদ হ্যাঁ my lord in this matter my lord that is no my lord
There is no appeal.
today my lord if my officer has come my lord and they said there is no any appeal pending in this case my lord appeal was pending appeal was
Comply
there
with the order?
yes my lord I must comply with the order
When?
give me some time
When was the order passed?
the same order was my lord that is 8 9 and 10 my lord same
order 21st of April
Same order, my lord.
2022. 21st of April 2022.
same order was there my lord and in one matter my lord I filed a review for that as the money was received by him and another matter
Can you see, my lord?
one of the learned friend my lord filed appeal
21st April 2022.
Yes.
my lord on the same day my lord two petition was disposed of by your lordship my lord directing to the and one matter my lord I filed a review that is
We are in
8 and 9
2024, Mr. Dev.
yes my lord and because my lord that and I filed a review that is 8 and 9 my lord that is the review and another matter my lord my one of my learned friend my lord filed appeal and that appeal was withdrawn for some
That was on technical grounds.
yes my lord. এটা বুঝতে পারিনি।
You have to initiate proceeding for direct purchase.
Yes, my lord. Already, my lord, in two cases, my lord, we have used after that, my lord, one case, my lord, I have seen that there is some money was paid to the person.
That will be adjusted.
Yes, my lord. Only for
My lord, it's a very humiliating for me. Last day, before the division bench, my lord, with great respect to your lordship, my lord, on consent, your lordship passed an order for direct purchase. They prefer an appeal saying that the learned state advocate has no power to give consent. And your
Some other matter.
some other matter. So one matter they are saying direct purchase we will implement, other matter they are challenging the in appeal.
Place,
a very-
place the records before the
Yes.
division bench.
I have already do that answer with lordship.
The-
Although their lordship has not interfered with your lordship's order. But this is the stand they are taken. One matter they are saying, yes,
Learned counsel for the alleged contender submits that no appeal is pending against the order under contempt. Stop. Learned counsel seeks the alleged contender seeks accommodation, counsel now, to comply with the order under contempt. Paragraph, let the matter appear under the same heading on 15th March.
deep love letter.
Paragraph, affidavit
My
of
lord,
compliance,
there is some more.
some more
My lord,
time, very well.
2 years have already almost 2 years passed again for that time.
On the previous occasion, my lord, they said they will file appeal, that is another advocate, my lord. But
No, no, you said that if paper
The state said,
state said,
never filed any appeal, so that another advocate.
but you submitted that appeal will be
Yes, my lord.
preferred.
As per my learned friends, my lord, direction, my lord, I pay before your lordship and submit that.
very well, please come back on 22nd.
My lord.
Yes, ma'am.
Let the matter appear under the same heading on 22nd March 2024. Paragraph, affidavit of compliance be submitted on the adjourned date.
Obliged to you.
Next. Yes, Complied?
We have got the letter, my lord, yesterday around 10 PM. The letter, the part compliance was already there. I'm handing over a copy to my learned friend. Original to the. But my lord order says, my lord, that the affidavit of compliance has to be filed, my lord. May I only pray for one indulgence part, my lord, the original is here, my lord. Yesterday, they say for the first time the office was open till 10 PM for this. But should be, my lord, because my lord, I have written a communication. Somebody has also misguided us. Anyway, my lord, now the things are absolutely, according to my humble submission, my lord, in order. And earlier, my lord, in as far as
Last paragraph, my lord, so far distance is concerned, my lord.
Yeah.
There is some distance. In the statement it is 2.4. The NOC 3.9. But
My
this
lord-
would follow the site plan.
my lord, the other one was, my lord, 7.5 meters.
Yes, yes.
So it is now 3.9. They have reduced it. They have, my lord, kindly see the earlier, my lord.
Sketch map, isn't it?
Yes.
Yes. It depends upon, my lord, the length where it is situated. If they want to dispute that, my lord, then it's been my humble submission, my lord. If they want to, may
That to the NOC in terms of our plan.
no, my lord, kindly,
You have stated as per proposed building plan.
Yes.
yes,
But what is the proposed building plan? What
But-
does it say?
well, that's,
Is it on record? Is it?
no, this is not on record. This has been given on 8th of February.
It should be in terms of the proposed
my
building
instance-
plan.
Yes,
Distance mentioned at 2.4.
no, this is, my lord, subject to correction. The earlier one was, my lord, 7.5 meters. No, if,
Different from this one, isn't it?
no, so if the distance is 7.5 meters for the first one, and my learned friend is correct, then here it should also be 7.5 meters. Instead of that, they said 3.9. Kindly consider this. Now,
Should be in terms of the building plan, right?
Yes.
yes, now the building plan according,
Because your document says,
yes,
nearest edge of your
My
construction.
lord, let that building plan come. I will also take my, yes,
Building
absolutely. I was not aware, my lord.
picture in that case.
Let the petitioners be present before the office
Huh,
with the original building plan and let them issue.
absolutely. Then let us sort.
And a date for submitting affidavit of compliance.
And kindly fix the date to.
So I'll record
No, my-
substantial compliance.
But this affidavits may be accepted. Yesterday, my lord was, please not even accept these affidavits. Yes.
Because I made it not today. I made it not today. That's why I didn't take that.
Yes, no,
Fast generally, so
no,
there was
yes.
no scope.
No, I understand. My lord, we fully appreciate the concern of the court, my lord, because we are the officers of the court. We feel very embarrassed.
Contempt application, no mercy, isn't it?
No, my lord has shown us enough mercy. Standing from Union of India, my lord, has shown the greatest possible mercy under the sun. একসঙ্গেই তো তিনটে দেয়া আছে। মানে let this letter be kept on record, my lord.
But this is not the original. Let the kindly fix time, my lord.
And this
Let
is the original.
Be present before the
Why don't you
authority.
annex this with your affidavit?
Yes.
Instead of filing a loose document,
Very well.
annex this with a further affidavit.
Yes. But my lord, there are two copies of original. One may be kept on record. The other one I will, or whatever, my lord.
Together, because it may get.
Yes, very well. Two point four बोल रहे हैं ना क्या? हाँ, एक देखिए.
7.5
कागज
with regard to the other construction.
Yes. অন্যটা দেখো আমাকে একটা কপি দিয়ে দিতে এটা
করেছো কবে?
তাহলে
আচ্ছা এমনি অরিজিনাল কাউকে ক্লায়েন্ট দিতে
হ্যাঁ
ক্লায়েন্ট যাবে অরিজিনাল নিয়ে যাবে।
আরে এখন নিন না আপনি একটা কি আছে অরিজিনাল
আমি তো রিসিভ করবো না ক্লায়েন্ট তো নিচে যাবে।
শুনুন এটা ঝামেলাটা মিটিয়ে ফেললে হয় আমি তো চেষ্টা করছি আপনি দেখতে পাচ্ছেন শুধু এটা
আপনার কোনো দোষ নেই ডিপার্টমেন্ট হারিয়ে ফেলে ডকুমেন্ট
আরে এরা পয়সা
ডিপার্টমেন্ট সিস্টেম
এরা খুচরো পয়সা চায় এ পয়সাতে যদি করে দিতে পারতো তাহলে সত্যি হ্যাঁ
Affidavits submitted on behalf of the alleged contender are taken on record.
তো হবেই রাত 10টায় টাইপ করেছে কন্ট্যাক্ট করে হবে না সিম্বলটাও নাই
Paragraph, it appears that the order under contempt has been substantially complied with. Only that part is in dispute.
And the original also different, madam. So let the petitioner be present before the authority. Two are different. Earlier one,
Different from?
the earlier one, there is
The
stamp of
prof-
the authority. There is no stamp, no logo.
No, logo is, the gentleman is here, my lord. It has been complied with this letter. I have personally asked him to be present, the person who has signed. He is present also because my learned friend now says this. Let them come, my lord. They will be given whatever this is. This is the senior.
Learned counsel for the alleged contender produces a letter issued by the senior divisional engineer within bracket 1, numerical 1, comma Eastern Railway, comma Howrah, on 19th February 2024, which indicates that the documents submitted by the applicant petitioner, petitioners,
He says
has been submitted to the competent authority and NOC has been granted for construction of the building in question. Stop. The applicant petitioners have been directed to strictly maintain the distance of 3.9 meters from the railway boundary to the nearest edge of the construction as per proposed building plan. Paragraph, learned counsel for the applicant petitioners submits that as per the proposed building plan, comma, the distance from the railway boundary is 2.4 meters. Stop. The petitioner seeks to appear before the authority with the proposed building plan in order to settle the issue. Paragraph, let the matter appear second week of March. Yes. Please file a complete affidavit on that date.
well, this affidavit is kindly take on record if possible, my lord.
Kindly
I've
fix
taken
a
the
date,
matter.
the petitioner will go there. Otherwise,
Let it be a mutually decided
Yes,
date.
yes.
When do you want to go, tell me?
tomorrow.
The petitioner wants to go tomorrow.
No, second week of March, the matter will be here. The petitioner has to go. When will he go? He gives us a date. I will communicate the date, my lord, to my learned friend.
But also compare this matter. There is earlier on logo, there is logo. In this matter, there is no logo. At the top,
Yes, my lord, as I have indicated, my lord, yesterday it was 10 PM, my lord, we could get this to comply with, it will be complied with, my lord. When we are submitting, my lord, we are taking the author and the person is here. There is no question of doubting this and the petitioner has to go, my lord.
Please appear before the authority, come back on the next date with all the details. And let the matter appear under the same heading on 11th March. Paragraph, affidavit of compliance is submitted on the adjourned date.
Deeply. Thank you.
ওটা ওনাকে ফেরত দিন। Next,
Deeply obliged, my lord.
please instruct your clients to.
We are, I will, we are,
No further order.
no,
needs to-
certainly, my lord, has given us enough indulgence, my lord. I feel very sad, my lord, to appear and
take time like this.
Next.
I'm for the contempt.
I shall file exception, my lord.
Yes,
I shall file exception because a petitioner is.
I will not grant you any further time to file
This
exception.
is the fifth time or sixth time.
Please no, no, no.
Last
Please submit
chance, ma'am.
your exception orally. Verbal exception will be accepted. What is
Last
your
chance.
objection? No, no, not at all. One,
And I
two,
is suffering from small pox, my lord.
Fourth or fifth,
4, 5.
sixth.
As a last chance, my lord.
Disposed of.
No, no, last chance, my lord.
No, no, no.
Kindly-
Please tell me what is your exception?
Kindly give me.
What is your exception, sir? I will not grant you any further.
Ready,
time.
but petitioner is ill, my lord, suffering
What is
from.
your exception to the affidavit?
That is not with me, my lord.
Order has been complied
So
with
it
in
will
due
dispose.
time, my lord.
I will not grant you any further time.
20 last,
There is a limit to everything, sir.
Kindly give me a chance.
page 26, my lord. 24th July 2023.
You submit your affidavit, isn't it?
Yes, my lord. Eleventh July, I have submitted my affidavit in
Give me a
compliance.
minute, please. Give me a minute, please. Yes. Where is the order disposing of the representation?
Page 26, my lord.
Page 26 is the sketch map.
Last page, my last page. Annexure কি গন্ডগোল হয়েছে? না গন্ডগোল তো হচ্ছে না। এই কোনটা বলেছেন? স্কেচ ম্যাপ তো 18 কথায়। ও কি হবে? করছে।
Where is the order disposing of the representation? This is the survey report, the demarcation report
গন্ডগোল হচ্ছে। না না উনি সার্ভে করছেন কেন?
given by the revenue inspector. Where is the order disposing of the representation?
My lord, last page of my affidavit of compliance.
Yes. Please show me. Didi, eta din.
একটা পেজিং কিছু গন্ডগোল হয়েছে। দিদি দাও দিচ্ছি মরেছে হুম
There is another affidavit of compliance, I think, isn't it?
Last compliance date.
9th August. No, this is 2023.
Yes. Just 1 minute. 9th August 2023. This is the wait আলাদা দিদি এটা দিয়ে দিন এটা আগে এটাই গন্ডগোল হচ্ছে 28 ঘন্টা উঠাই জমা দিয়েছি মনে হচ্ছে
My lord, I am not advocate in record, my lord. My advocate in record has not come, my lord. He has sent the message.
Your prayer is rejected, sir. I'm sorry. Learned counsel for the applicant's petitioners seeks further accommodation to use an exception to the affidavit of compliance. Stop. In view of the fact that such exception has not been filed by the applicant's petitioners despite several opportunities granted to them, comma, the prayer is rejected. Paragraph, it appears from the affidavit of compliance that the order under contempt has been complied with. Paragraph, in view of the above, the contempt application being CPN such and such is disposed of. Paragraph, there shall however be no orders to costs, urgency to proceed. Next.
My lord, in this matter, my lord,
My lord, this is a contempt application arising out of violation of the order dated 31st January 2023, wherein
You are appearing in this?
yes, ma'am.
wherein the respondent number 2 was directed to reconsider the representation of the petitioner in the light of the order passed by the learned court below, my lord.
My lord, in this case, my lord, if your lordship will see, the DM passed the order in appeal, my lord, that is the DM passed the order, my lord, to the effect that your lordship was pleased to direct that there was he filed a suit, my lord, and there, in the light of that suit, my lord, DM was directed to consider the appeal, and appeal was considered and set aside the order of the SDO, my lord, and sent back to the assistant engineer to file a fresh
What
notice
is the
to the
affidavit of compliance, Mr. Dev?
my master, my lord, yesterday, as because my lord, yesterday only for that reason, my lord, if your lordship will see the order.
It has been passed in your favor, but let the
Yes, my lord. Kindly keep the matter pending.
with the affidavit,
Yes,
yes, with
ma'am.
the affidavit of compliance. Will you take this back? Because you have to annex this with the affidavit of
Yes,
compliance.
ma'am.
It is submitted on behalf of the alleged contempt
এটাতে annex করে দেবো
that
তুমি পাবে তোমাকে
the order under contempt has been complied with. Paragraph, learned counsel seeks to submit affidavit of compliance on the adjourned date. Paragraph, let the matter appear under the same heading on 4th March,
yes,
because you are ready with it.
yes, ma'am.
Next.
But appears on the petition, my lord. But this contempt application arising out of the order passed by my lord dated by 27 January 2023.
For the first time.
No, no. My lord, my lord was order passed by my lord is at page 32, my lord, whereby my lord was pleased to direct the appellate authority under my lord West Bengal Inland Marine
There is a
Fisheries Act.
service.
But they have passed an order after service, my lord. After effecting service, my lord,
Complied.
they have passed an order, my lord,
It is complied.
rejecting my appeal, my lord. It gives rise to face cause of action, my lord. But that order has been passed, my lord,
So the order has been complied.
or
with.
compliant. My liberty may be to challenge, my only, my lord.
Necessary, you have the liberty. The law gives you the liberty.
My But since, my lord, under section 18, my lord, it has to be disposed of within 3 months, my lord. Appeal was filed on 4th August 2023, my lord, and they have disposed it on 24th January 2024. my lord.
That's why the contempt. It is submitted on behalf of the alleged, behalf of the applicant petitioner that the order under petitioners, that the order under contempt has been complied with. Paragraph, in view of the above, the contempt application being CPN such and such is disposed of. Paragraph, there shall have been orders to costs, urgency to website.
My order may be kept.
The order passed by the Appellate Authority under section 18 of the WBIF Act 1980 IF Act Inland Fisheries Act 1984 on 24th January 2024, produced by the applicant petitioners, is taken on record.
Good.
Next.
I am for the petitioner, below.
Yes.
I am for the private respondent. The last occasion, the report, your lordship direction to file a report by the state.
But there is a case of filing report for her, it is yet to affirm her. Can you ask what date when we fix for her? It is ready, our government.
Our appellate authority passed order of demolition, which has been challenged before lordship. And that
My lord,
proceeding
this
was
is-
initiated pursuant to an order passed in under my lord, public interest litigation.
Yes, yes.
And my lord, this is a case of the petitioners that they are owner of the property, and that's not being disputed. The case as is
My
being
lord, this is
reflected
the
in the
matter
order of appeal, my lord,
Requires
that they
of
have
hearing
enforced
or
public
merit.
road
Well, it is
while
required to be
constructing on
very-
their own land.
My lord, it is required hearing on merit.
Page
Today is the date, my lord, fixed for
page
filing
four
the report.
34. That clarifies everything.
Where is the date fixed for?
For the filing report by the state. So he's submitting the report.
Let them come back with the report. That will clarify the entire situation, I believe.
The interim order is still disposal of the
But
report.
Yes.
Interim order till disposal of
interim
the
order
report.
is there.
Interim order is still disposal.
Yes, yes,
So
yes.
that is the Supreme Court observation, your lordship's also.
There could not have been any other option.
Yes.
Learned counsel for the.
Or I am submitting my affidavit.
If we have copies of that, that we
Yes.
But no copy has been served.
I'm supplying.
You'll serve copies, don't worry.
Yes,
You are for the private response.
private response.
This is the,
This is
But
their
their
affidavit.
direction was there for filing my lord report. But I cannot file and report. So I have said supplementary affidavit that I used one time.
So without taking leave of the court, my lord, the
There
supplementary
was a
affidavit.
direction for filing report, but I can't file a report.
respondents, but the private respondent cannot file a report, isn't it?
That's why
I'll just record it as an affidavit.
so the copy may be served. my lord.
Yes, yes. Just
Affidavit
by
shall be
5 minutes I am
submitted of the Private respondent is taken on record.
My lord, I am
Counsel
submitting,
for
supplying
the
to my
state respondents. State respondents seeks extension of time to submit the report in the form of affidavit as
অর্ধেক তো পড়াই যাবে না গো।
sought.
যা
Currently,
পেয়েছি তাই
the
দিচ্ছি।
matter appear under the same
Okay.
heading
কোর্টকে
on
তো ঠিক কোর্টকে তো ঠিক দিচ্ছ না।
March.
মানে
20th March, my lord, fairly at the top, my lord, because order of demolition pursuant to order of public interest litigation.
State.
প্রাইভেট রেসপন্ডেন্ট দিচ্ছে।
That is state.
রিপোর্ট দেয় না। 20th March, your lordship fix. Okay.
Great, my lord.
Lordship, give me a moment, Mr. Mitra is here.
গিফটটা দাও ভাই দাদা।
Mention matters will be taken up at 12:30.
Yes. Normal motion, not up.
So we will continue today first and on the point of suppression.
আজকে আমি চেষ্টা করবো তাই 11:30 পর্যন্ত 12:30 পর্যন্ত
Yes, Mr. Mitra, suppression.
Yes, well, on the separation, well, what I propose doing is, well, first I want to place the judgment on which I want to rely. Well, that is reported in 2008-12 Supreme Court cases.
Is everyone there? The added respondent?
The added respondent he's just valid from side. He's even absent in the suits.
Anyway, we'll continue. Yes.
Added respondent is not appearing. It's very unrepresented, I'd rather say. It's appearing unrepresented.
The interest of the added respondent is not involved at all. Anyway, your lordship will kindly take, my lord, this judgment of the 2008-12 Supreme Court cases, page 481. Well, I shall only place just 2 or 3 paragraphs. This is just by way of preface to my submissions. Kindly come to paragraph 34. Suppression of material. Judgment reference হচ্ছে 2008-12 Supreme Court cases, page 481. Para 34 to 39.
Yes.
Kindly see, my lord, para 34. The jurisdiction of the Supreme Court under Article 32 and of the High Court under Article 226 of the Constitution is extraordinary, equitable, and discretionary. Prerogative writs mentioned therein are issued for doing substantial justice. It is therefore of utmost necessity that the petitioner approaching the writ court must come with clean hands, put forward all the facts before the court,
without concealing or suppressing anything, and seek an appropriate relief if there is no candid disclosure of relevant and material fact. কি হলো নাকি তোমাদের? এত আওয়াজ করলে কি করে হবে বল? হ্যাঁ, কপি আছে বই কি? কপি দেয়নি আপনাকে? আমি কোনো ডিসিশন সাইট করি না without giving it to the other side. It is if there is no candid disclosure of the relevant and material facts, or the petitioner is guilty of misleading the court, his petition may be dismissed at the threshold. This is what I was submitting, without considering the merits of the action. The underlying object has been succinctly put by Lord Justice Scruton in the leading case of R versus Kensington income tax. Well, this is a leading case all over. It has been for many years the rule of the court, and one which is of the greatest importance, to maintain that when an application comes to the court to obtain relief on an ex parte statement, Bosho, sit down. Ex parte statement. To the court to obtain an ex parte statement, he should make a full and fair disclosure of all material facts. It says facts, not law. He must not misstate the law if he can help it. The court is supposed to know the law, but it knows nothing about the facts. And the applicant must state fully and fairly the facts. And the penalty by which the court enforces that obligation is that if it finds out that the facts have not been fully and fairly stated to it, the court will set aside any action which it has taken on the faith of the imperfect statement. A prerogative remedy is not a matter of course. While exercising extraordinary power, a writ court would certainly bear in mind the conduct of the party who invokes the jurisdiction of the court. If the applicant makes a false statement or suppresses material fact or attempts to mislead the court may dismiss the action on that ground alone and may refuse to enter into the merits of the case by stating, quote, "We will not listen to your application because of what you have done," unquote. The rule has been evolved in the larger public interest to deter unscrupulous litigants from abusing the process of court by deceiving it. Well, it's very strong language. Then Kensington Income Tax Commissioner Viscounts, this is also a very readable paragraph of Chief Justice Viscount Redding, where an ex parte application has been made to the court. In this case, ex parte application was made and interim order was obtained for a rule nisi or other process. If the court comes to the conclusion that the affidavit in support of the application was not candid and did not fairly state the facts, but stated it in such a way as to mislead the court as to the true facts, the court ought, for its own protection and to prevent its abuse of its process, to refuse to proceed any further with the examination on merit. This is a power inherent in the court, but one which should be used in cases which bring conviction to the mind of the court that it has been deceived. Before coming to the conclusion, a careful examination will be made of the facts as they are and as they have been stated in the applicant's affidavit, and everything will be heard that can be urged to influence the view of the court when it reads the affidavit and knows the true facts. But if the result of the examination and hearing is to leave no doubt in the mind of the court that court has been deceived, then it will refuse to hear anything further from the applicant in a proceeding which has only to be set in motion by means of a misleading affidavit. The aforesaid principle has been accepted in our legal system. As per the settled law, the party who invokes extraordinary jurisdiction of the court under Article 32 or of the High Court under Article 226 of the Constitution is supposed to be truthful, frank, and open. He must disclose all material facts without any reservation, even if they are against him. He cannot be allowed to play hide and seek or to pick and choose the facts he likes to disclose and to suppress, keep back, or not to disclose, conceal other facts. The very basis of the writ jurisdiction rests in the disclosure of true and complete correct facts. If material facts are suppressed or distorted, the very functioning of the writ court and the exercise would become impossible. The petitioner must disclose the facts, having bearing on the relief sought without any qualification. This is because the court knows law, but not the facts. My lord, after this, I will just request your lordship to come to the penultimate paragraph at page 497, paragraph 52. In the case on hand, the appellant has not come forward with all the facts. He has chosen to state the facts in the manner suited to him by giving the impression to the writ court that an instrumentality of the state sale has not followed doctrine of natural justice and fundamental principles of fair procedure. This is not proper. Hence, on that ground alone, the applicant cannot claim any equitable relief. My lord, I am very strongly relying upon this particular. Before, my lord, I come take your lordship into the facts. My lord, in the facts of the instant case, if your lordship looks into the petition, what they have come forward with, what case they have come forward with. Kindly take, my lord, the petition, writ petition, paragraph 7 and 8. Sorry, give me 1 second.
Yes.
Supplement here. আর এটা দেখো তো তোমার পিটিশনটা এটা। My lord, kindly come to paragraph paragraph 6, that the petitioner state that thereafter of a preliminary decree dated 28 to 1963, one commissioner of partition, namely Pratul Chandra Datta, was appointed as special referee by the High Court to do acts and things mentioned in clause 31 of the terms of settlement or solemnament, dated 28 1963, and as per preliminary decree passed on so and so, that subsequently by an order dated 16th August 1972, passed by the High Court, one Mr. Motilal Banerjee, Bharat Law, now dead, was appointed as the receiver to manage and control the estate. Then, my lord, para 7, that the petitioner state the said special referee and commissioner of partition Pratul Datta, having been appointed by the High Court by order dated so and so, proceed to do acts and things mentioned in clause 31 of the terms of settlement or solemnament mentioned above, and surveyed the suit properties and submitted his detailed report dated 28/5/1977 before the High Court for acceptance, wherefrom it appears that the property specified in clause 31 of the said terms of settlement, III and 24(1), the Palace of Motiabag, with compound comprising of an area of 75 bighas or thereabout, as may be ascertained by the special referee, item number 1 and 1/3 share of the property mentioned in para 24H and I, and 1/3 share of Kumar Pramothesh Borua, and 1/3 property of Pramothesh Chandra Borua of clause so and so, Kacharibari in Assam, were allotted to Allocation Chandra Borua, Shamulesh Chandra Borua, and Arup Kumar Borua. As legality of Pramothesh Chandra, as legal should be legal heirs of Pramothesh Chandra Borua. The petitioner, being daughters of the said Arup Kumar, now dead, had acquired right title and interest upon the said property. And this is the case that he is making. That the fact would be evident from number 147 filed on so and so, etc. And the decree passed on the basis of terms of settlement. The respond number 8, 9, 10, 11, and 12 and 13, that is outlined, of this writ petition or their predecessor, who were added as defendant number 1C, 1D, 1E of the partition suit, being so and so, cannot claim any exclusive right. Kindly note these words. Title and interest in or upon the property of the palace, Hawakhana at Motiabag, with compound comprising of 75 bighas or thereabout, as may be ascertained by the special reference. In other words, the respond number 8, 9, 10, 11, and 12, and 13 of this writ petition have had no right to sell, transfer, or mortgage any portion of the palace, Hawakhana Motiabag, which fell in the share of the petitioner, being legatee and daughter of late Arup Kumar Borua, as the preliminary decree dated so and so, passed in so and so. It is stated that the final decree in the preliminary decree dated so and so on basis of report of commissioner is yet to be passed by the Honorable Court. Then the petitioner state the respond number 8, 9, 10, 11, 12, and 13 are the sons of the legal heirs of Prokritish Chandra Borua cannot claim right title and interest in respect of any property in the partition suit, which does not fall in the share of original defendant Prokritish Chandra Borua as per preliminary decree dated so and so, passed in so and so. So, my lord, what is being said here, my lord, if I may just summarize, that this particular property, HON'BLE, this belong to everybody. All the heirs of Prokritish Chandra Borua and my lord Arup Borua, who is the predecessor in interest of the writ petitioners. And therefore, since the property has not been partitioned as yet, therefore, no part of this property could have been sold or could have been, my lord, taken possession of by anybody without reference to the writ petitioners. That is the summary of the whole thing. Now, my lord, what I am seeking to show before your lordship is that the writ petitioner did not tell your lordship what has happened insofar as HON'BLE is concerned. My lord, there, the affidavit in opposition of respondent number 1 to my lord, we did not want to, my lord, unnecessarily burden it. My lord, respondent number 1 to 7, in their affidavit, they have annexed, my lord, these documents. I am going to hand up to your lordship a short note, which perhaps your lordship may assist your lordship. I have summarized in this. Well, may I hand up to your lordship? Your lordship can take it as a sort of index. I mean, to copy the other. Copy ache আমার কাছে?
Yes.
Oh. Very. আমি একটা কপি দিয়ে দিচ্ছি। Now, my lord, this note, if your lordship follows this, in 1960, administration suit number 993 was filed in the High Court. Suit was filed by Jamuna Borua and her children against inter alia the predecessor in interest of the writ petitioner. Your lordship has got that chart, that family chart. There is a genealogical table, my lord. Lordship sees this. It is like this. একবার দেখুন।
দিদি দেখুন তো এর মধ্যে হবে।
It
will be there. Yes.
But I can hand over another copy. If you know.
I think, my lord, is better that your lordship can take.
এখন নেই নিচে এখন। Yes.
Before I, my lord, place this, kindly take this genealogical table. My lord, kindly see that Prabhat Chandra Borua, Raja Prabhat Chandra Borua, had sons and daughters. Now, by law of the primogeniture and, my lord, by the law that was prevailing, the daughters didn't have any share. So this Promothesh and Prokritish, your lordship can confine, my lord, to Promothesh and Prokritish. So far as Promotesh's branch is concerned, kindly see that on the extreme left,
Yes.
Madhuri Lata, your lordship sees that, and her children, my lord, Alokesh, Shamulesh. Then, my lord, Amol Bala, that is, my lord, next one. Her, my lord, heir is Arup. Arup is, my lord, the predecessor in interest of Moshumi and Orpita.
The petitioner.
Yes, petitioners. And, my lord, kindly go back to the 5 children of Raja Prabhat Chandra Borua. First, second, third, fourth is Prokritish Borua, your lordship sees. And I have drawn this line. The one which are there at the bottom, Pradeep, Prabir, Pradut, Pritam, they are, my lord, respond by 8, 9, 10. Now, my lord, kindly keep this in mind, and your lordship will be pleased to see what happened. My lord, this particular, your lordship will kindly come back the notes. In 1960, administration suit was filed, and, my lord, suit was filed by Jamuna Borua and her children against inter alia the predecessor in interest of the writ petitioners, namely executor to the will of Promothesh Borua. My lord, Jamuna Borua, my lord, filed the original suit. Kindly, my lord, come to page 90 of the affidavit in opposition. This is a thick affidavit in opposition of the affidavit in opposition of R1 to R7.
By respondent numbers 1 to 7.
By the state trust. Well, kindly take page 90.
Page?
90. I have given, my lord, in my notes of argument.
Yes.
This is, my lord. If your lordship take this is an administration suit, and in this suit, it at page 90, page 101. Now, before your lordship comes to a, kindly come to page 90 and 92.
Yes.
This 90 to 92, your lordship sees the cause title in this partition suit. All the heirs are there, including my lord Arup Kumar Borua, respondent number 9, who is the predecessor in interest of Moshumi and Orpita. This your lordship will be pleased to find in the genealogical tape. So they were there before the court. And it has been recorded in the return, whereas by a preliminary decree for partition passed by this honorable court in the above suit on the 28th August, I was appointed commissioner. I, meaning thereby, my lord, Pratul Datto, was appointed the commissioner 28th August. I was appointed commissioner of partition to do the acts and things, etc. Now, my lord, kindly take my second point in my note. In the suit, a preliminary decree was passed on 28/8/63. This your lordship will please to find at page 204.
Yes. Terms of settlement.
Yes, Mala, this is the terms of settlement were filed, which has been referred to in their petition. This is the terms of settlement. And in terms of this, this is from page 204 to 27. Well, I am not troubling your lordship. These terms were signed by the predecessors in interest of the writ petitions. In terms of clause 29 at page 205, PC Doctor was appointed. Kindly, my lord, come to page 205. PC Doctor was appointed, my lord, the commissioner of partition. Sorry, I think I'm at page clause 29, not page 205. I think there's a typographical error. It should be page. Yes, page 215. My lord, kindly correct it, my lord. I'm sorry. It should be page 215. In terms of clause 29 at page 215, Mr. PC Doctor Solicitor was appointed special referee. Kindly see.
Yes.
Page 215, the last clause,
Yes.
the PC Doctor is hereby appointed Commissioner of Partition and Special Referee. These are all by consent of the parties. Then, my lord, kindly come to page 213 of this. I hope, my lord, I have given the correct page number. Yes, 213. The immovable properties that have been mentioned. At page 212, my lord, bottom, it is declared that the following immovable properties belong to the estate of Raja Prabhat Chandra Borua. Last sentence. Then kindly come to page 213. It is I, subclause I.
Yes.
Palace of Mutiabag with compound comprising of an area of 75 acres or thereabouts, as may be ascertained by the special referee. So, my lord, this was one of the by parties consented that this should be partitioned. Then what happened was this. On 28th May 1977, paragraph 3 of my note, Commissioner of Partition filed his return. This your lordship will please to come back, please to come to page 89. This is the return. At page 92, your lordship will please to find the cause title starts from page 90. At 92,
yes,
the return whereby whereas by a preliminary decree for partition passed by the Honorable Court in the above suit on 28th day of August 1963, I was appointed Commissioner of Partition to do the act and the said preliminary decree. Now, my lord, the Commissioner filed this return, and this return is from page 89 to 134. I'm not troubling your lordship with this. In this return, he recorded at page 102. This is very important. Page 102. I am just referring your lordship to the relevant portions.
Page 102.
102.
Yes.
In my note, your lordship will please to find item 4. Page 102, 103.
Yes.
Kindly take the top II. The parties represented that some portions of Rajbati, as also Motiabag Palace, has been disposed of by the parties, and portions thereof have been acquired by the state of Assam. The parties interested in Rajbati and Motiabag Palace, as aforesaid, submitted, kindly note this, submitted that they had mutually effected partition of the undisposed of and unacquired portion of Rajbati and Motiabag Palace amongst themselves, and that they have already taken exclusive possession of the portions thereof, respectively allotted to them on such mutual partition. Well, each word is important. All mutual partition. And Arup was a party to this. Thereupon, I, note this word, with the consent of the parties, appointed surveyor to survey the two properties and prepared plans showing the respective portions of the said two properties taken by the parties, note these words, entitled thereto respectively. Two plans were prepared, and the portions of Rajbati and Motiabag Palace were taken by the parties entitled thereto, were separately indicated therein. The said plans were signed by all the parties interested as a token of their acceptance of the portions respectively, shown to have been taken by them on mutual partition as aforesaid. The said two plans with the signatures of the parties entitled thereto is annexed hereto and marked A and B. Now, my lord, I pause here for a moment. Therefore, what I am placing before your lordship is a document of ancient origin, a return of the Commission of Partition. Nobody has taken any exception to this return, in which, my lord, the Commission of Partition has himself recorded that the entire thing with regard to Motiabag Palace was done with the mutual consent of parties. I expected, my lord, I very humbly submit to your lordship that in a 226 application.
That was not accepted. That report was not accepted.
Sit down, please sit down, please sit down. I'm
That
sorry to
report was
tell
not
you.
accepted.
Have your turn, sir.
I am.
It was not accepted. I shall show you. A Kalnemi Lanka Bhag. This is called Kalnemi Lanka Bhag. You just wait and see how I develop it. হ্যাঁ দেখা যাক accepted by the court কিনা আপনি দেখান না কিছু একটা বার করুন. Why did you suppress this fact? Why did you suppress this particular fact? This is absolute suppression.
It is not a suppression.
Then, my lord, kindly see. My lord, how things have gone. The said two plans, signatures respond. Then, 5, kindly note 5. It is at a very late stage of the proceedings. On 8th and 9th May 1977, the parties interested in the Rajbati and Motiabag Palace jointly represented that the land comprised in Khatiyan number 365, Dag number 562, shown in the plan annexed hereto and marked B as allotted to and taken by and shown in the survey records as belonging to Kumar Prakritish Chandra Borua was in fact joint property and should be divided amongst the parties. They also submitted a plan being annexed here D hereto, indicating that the 4 different portions of Dag number 562, one without color and comprising 2 bighas, which had already been sold away by Kumar Prakritish Chandra Borua and Shamalesh Chandra Borua. The second portion, colored yellow, comprising of so-and-so, which has been taken by Sri Allocation Chandra Borua, Arup Kumar Borua, my learned friend's client's predecessor, and Shamalesh Chandra Borua. The share of Shamalesh Chandra Borua being 1/3 of 4 bighas, 2 katas, 1 bigha of which has been sold by him. The third portion, colored blue, comprising of area of 4 bighas, 2 katas, so-and-so, taken by Sri Jayasri Borua and Sister Shubhasri Borua. And the fourth portion, colored so-and-so, taken by Prakritish Chandra Borua. Then 4, in these circumstances, kindly note, I effected partition of the Rajbari at Motiabag Palace amongst the parties entitled thereto by respectively allotting, and see, my lord, how the things have been allotted. I am going to show to your lordship, my lord, how it has been allotted. And parties have taken possession of all this. See, Kumar Prakritish Chandra Borua, the portions of Rajbati and Motiabag Palace fully described in part 1. Kindly, my lord, make a note of it. Page 131 is this part 1. Kindly, my lord, take page 131.
Yes.
This portion A, part 1 is page 131. Motiabag Palace, item 2. Khotian number, dag number. Quantity of land. They have been mentioned. 33,410. 33 bighas, 4 katas and 10 lachas. Then, my lord, kindly take part 1 is, then, my lord, kindly come to part 2. I am not troubling your lordship. B. See, Jayasri Gogoi and Shubhasri Bodua, they are not, my lord, contesting this. Kindly come to, my lord, C. This will clinch the issue to Alokesh Chandra Bodua, Shamolesh Chandra Bodua, Arup Kumar Bodua. Kindly see C.
Yes.
Of the portions of Rajbati and Motiabag Palace fully described in part 3 of the second schedule here too, and shown in annex plan, page 132. Kindly make a note of it. This is at page 132. 132, the last one. Oh, sorry. This is a middle of it. Page 132, part 3. Portions of Rajbati and compound and Motiabag Palace and compound allotted to Alokesh Chandra Bodua, Shamolesh Chandra Bodua, and Arup Kumar Bodua. Who is Arup Kumar Bodua? My lord, they are, my lord. He is the predecessor in interest of this. So it was allotted like this. And my lord, kindly see the last. The first is Motiabag, Rajbati and compound. We are not really concerned with this. This was allotted to Arup. And then Motiabag Palace. They were given, my lord, a larger portion of the Rajbati. So naturally, consequently, my lord, Motiabag Palace, Hawa Mahal, smaller portion. That is, my lord, Motiabag Palace and compound, 366, 365. This is what was allotted to Arup. And this was by consent of the parties. Not only that, I shall show to your lordship that they took possession of these properties. And that has been recorded in the report.
So the subject matter of the dispute here. This 560 has not gone through.
At page 131, I have shown to your lordship that page 131, what has gone to come to my client's share at page 131 is, my lord, kindly see the Khatiyan number 2, item number 2, Motiabag Palace and Compound, 365 Khatiyan number, dag number 560.
This is the issue.
This is the issue. This dag number 560, which is, my lord, 13 katas, 1 chatak and 1 lacha. That is, my lord, the subject matter of dispute. That was allotted to me. Allotted to the predecessor of my client. Now, my lord, kindly come back to my note. I have shown your lordship how it has been done. Then, my lord, with the consent of the parties, surveyor was appointed, prepared plans showing portions of the properties taken possession of by the parties to which they are entitled. This I am quoting from the report. And they were separately indicated in the plan. These plans were signed by the parties as a token of their acceptance, which, my lord, was signed also by Arup Bodua. These were annexed to the report as annexure A and B. In subparagraph 5, it has been recorded that a very late stage of the proceeding before the commissioner, parties prayed for some readjustment because the land comprised in Khatiyan number 365, dag number 562, shown as belonging to Prokritish Bodua, was in fact joint property and should be divided among the parties. Whereupon the commissioner took note of such fact in effecting partition. Taking note of all the aforesaid facts, the commissioner effected partition of Motiabag Palace and made allotments. These are at pages 131, 132, which I have just now placed. Allotment in favor of the predecessor and interest of the writ petitioners in Motiabag Palace is in part 3 at page 132. I have shown to your lordship. On 27th October 1987, Prokritish Bodua, the father of Pradeep, Pradut and Pritam, made his will, affidavit in opposition. This page is 135 to 141. The probate of the will was granted on 5/7/97. I have given the page number of each one of them, and that is at pages 182 to 197. Considering all the aforesaid documents, the Deputy Commissioner, Dhubri Land Settlement Branch, passed the order dated 8 December 2022. My lord, significantly, this order which is at pages 201 to 203. Well, this order has not been challenged. I have made a note of it. This order has remained unchallenged. No mention of it in the writ petition. The writ petition has not stated anything about it, not even challenged it. Then, my lord, para 7. In consonance with the above order, additional deputy commissioner and land acquisition officer, Dhubri, issued payment order dated 9/1/2022 for rupees 13 crores 15 lakhs after deducting 1 crore 50 lakhs towards TDS in favor of the respondent. That is affidavit of on page 306. Well, I think it is better that I should show to your lordship. Kindly come to page 201. 201, 203.
Yes, the order.
At page 8 December 2022, which I have mentioned in paragraph 6 of my note. I am not troubling your lordship with the first portion of the order, which is recording, my lord. It's only the recording the facts. Whereas it is also to be mentioned that last paragraph at page 201, Sri Pratima Pandey Bodua, in whose name the government of Assam has planned a restoration museum, is also a daughter of late Prakritish Bodua. Whereas Cultural Department, as per the report of the Purchase Committee, informed the undersigned that rupees 15 crores has been sanctioned for acquisition of land of Motiabag Palace. Whereas on 17th October, a prayer petition was received by this office from Srimati Mousumi Bodua Roy, my learned friend's client, daughter of late Arup Bodua, who is also another son of Raja Prabhat Chandra Bodua. In her petition, Mousumi Bodua has stated that she came to know about the purchase of HON'BLE by the government from the media reports, and that the sons of late Prakritish Bodua had gone ahead with the negotiation without settling family property dispute. Srimati Mousumi Bodua mentioned about a decree by consent passed by the Honorable Calcutta High Court on 28 August 1963 in the administration suit, submitted a copy of the terms of settlement. Whereas on the original decree and terms of settlement, it is seen on page number 2 on the first schedule, the land under Khatian number 365 and DAG number 560, which I have just now showed to your lordship, and 562, is given under joint names of Kumar Prakritish Bodua, Pranavish Chandra Bodua, and Madhurilata Bodua, and 3 sons. Whereas the sons of late Prakritish Bodua, represented by Sri Probir Bodua, my lord, my client, were sent a notice regarding the terms of settlement and adherence thereof on 30/11/2022. In response, Probir Bodua submitted on 5/12/2022 a copy of the return of the Commissioner of Partition of Sri Pratul Chandra Datta, Advocate Commissioner under the order dated so and so, without the original administrative suit, is also out of the original administration suit. It should be 993 of the Honorable High Court. Whereas on perusal of the above return, in page number 6, in second schedule, it is mentioned that portion of Rajbati compound at Gauripur and Motiabag Palace and compound allotted to Kumar Prakritish Chandra Bodua mentioned has been made in Khatian number so and so, and the particulars have been given. Whereas another complaint was received from one Kanchanmala Bodua, reportedly a daughter of Prakritish Chandra Bodua, from a different wife. Whereas in response to the claims, Probir Bodua submitted a will executed by late Prakritish. This is the will I have given your lordship, and probated by the Honorable District Judge, mentions about the inheritance of the landed property at Motiabag. Only the 4 sons, namely Pradeep, Probir, Pradut, and Pritam, who are, my lord, respondent number 8 to 13, will get shares and no one else, and no daughters. Hence, from the above document, it is established beyond doubt that for the aforesaid Dags at Motiabag, Gauripur, the 4 sons of late Prakritish Bodua are the rightful beneficiaries of the compensation. The 2 complaint receipts do not stand, at least in the context of purchase of HON'BLE and payment of the compensation thereof to the above intended beneficiaries. In view of the above documents provided, and in compliance with the distribution of landed property at Gauripur in so and so, DAG number so and so, Government of Assam, the recipient of the compensation amount will be the 4 sons of Prakritish Bodua. My lord, first of all, this particular order was passed because of the objection raised by my learned friend's client. And on that, this order has not been challenged. This order has not been even produced before your lordship. I say, what bigger, my lord, suppression of material facts can there be? And this is exactly what has been condemned in that Supreme Court judgment. This entire order, without challenging this order, my lord friend has come to the court. And this, my lord, I respectfully submit that insofar as the government of Assam is concerned, they had taken, my lord, immense amount of trouble for the purpose of going into these documents, looking into the facts, finding that these particular properties have been taken allotment by the parties, they have taken possession, and therefore the person who is raising objection has no reason to raise any objection. And thereafter this order was passed. This order has not been challenged for your lordship. Then, my lord, kindly come to paragraph 8 of my note. On 9 December 2022, agreement was concluded between the requisitioning authority representing the Director, Cultural Affairs, Government of Assam, and R8 to R13 regarding acquisition of Motiabag Palace and payment of compensation. This your lordship will be pleased to find at page 307. My lord, I have, my lord, taken the trouble of analyzing the entire brief of documents, and I find that these documents have not seen the light of the day in the writ petition. 306 to 315.
307.
My lord, kindly see these documents. These documents are lying unchallenged. What kind of a writ petition is it? 9/12/2022, the amount has been paid, the amount has been released, and my lord, agreement with the landowners, your lordship kindly takes, my lord, page 307. This is an annexure to, my lord, page 306. This entire document is there on the basis of which, my lord, the compensation was paid. After the authorities were fully satisfied that the writ petitioner who had, my lord, raised an objection had no cause to raise any objection. And thereafter only, my lord, had come to the finding, and my lord, this amount has been paid. My lord, this I have recorded in my, then, my lord, this is at paragraph 8. Then on 28 December 2022, Additional Deputy Commissioner and Land Acquisition Officer Dhubli directed the Circle Officer Gauripur Revenue Circle, Dhubli, to correct the land records in respect of Motiabag Palace. This your lordship will be pleased to find at page 316. Land record has been corrected also. What they are challenging, I don't know. Kindly see, my lord, on 28/12/2022. These have not been challenged at all. Not only, my lord, suppressed, not challenged. With reference subject above, I would like to enclose here with a copy of the deed of agreement with the landowners duly endorsed by Senior Sub-Registrar Dhubli, so-and-so land acquisition through direct purchase by way of negotiation settlement for Department of the State of Assam, connection with the development of the house, late Tambodwa, Motiabag Palace in Gauripur district, Dhubli. You are requested to take necessary steps for correction of the land records in favor of the requisitioning agency represented by Director of Cultural Affairs. My lord, on merit also they've got nothing to say. This is, my lord, at page 316. Then your lordship will please to turn over the page. I want to finish this side of my submission, my lord, today. And my lord, I have written no challenge to this in the writ petition. Absolutely no challenge, not a whisper. Then, my lord, in terms of the aforesaid proceeding, the land records pertaining to Motiabag Palace has been corrected, and that your lordship will be pleased to find in the affidavit of, my lord, the Government of Assam. They have given page 316 to 326. The already land records have been corrected, and they have not, my lord, questioned it before your lordship. Because now, today, there is a fait accompli. All these things have been done. And to the knowledge of the writ petitioner, neither the writ petitioner told your lordship about it, nor did the challenge. Then, my lord, 11. What has further been suppressed by the writ petitioner is that, this is very important, in terms of the commissioner's report as aforesaid, the writ petitioner, not right petitioner, writ petitioners or their predecessors have sold off portions of Motiabag Palace allotted to them by and under the return of the commission. They have given effect to it. What they have done is this, that portion I have shown to your lordship, which has been allotted to them, they have themselves sold them away. And now they are questioning, what are you doing with your allotment? This is not a gross separation of material facts and misleading the court. And my lord, this I have given in the supplementary affidavit, which I have filed. My lord, kindly make a note of it. Supplementary affidavit, pages 15 and 16. Yes. Your lordship will be pleased to see. Come, my lord, the supplementary affidavit.
Yes.
Pradyut Kumar Borua has affirmed this supplementary affidavit dated 22nd September 2023.
Yes.
Dekun to, Judge Sahib ke eta din na.
I have it with me.
Your lordship has got it. Kindly, my lord, come to page 15, 14, 15. Kindly see, if I may just show your lordship. I am not troubling your lordship with the other portion. They have sold their portions, they have sold themselves. My lord, kindly come to page 12.
Yes.
This is the with regard to Prakriti Chandra Borua. Kindly come to the last few lines. Be it mentioned that one bigha 4 katas 12 lechas of land in old Dag number 405 has been sold by deed of sale, that being the heirs of late Alokesh Chandra Borua, Shamulesh Chandra Borua, and Arup Kumar Borua, sons of Promotesh Chandra Borua, and their heirs, Goripur Town, so and so, and old Dag number 560, 13 bighas 1 kata 1 lacha, so and so, of Prakriti Chandra Borua recorded in the name of so and so. 3 persons, it has been recorded in the name of Assam Government Cultural Department. So, my lord, a portion has been sold by them, a portion has been sold by us. Similarly, my lord, if your lordship kindly comes to page 14, the particulars of the land at the top, sold by Alokesh Chandra Borua, Shamulesh Chandra Borua, Arup Kumar Borua are given below. So their predecessor interests have sold the lands which have been allotted under the Commission of Partitions return. Similarly, my lord, page 15, particulars of the land sold by Alokesh Chandra Borua, Shamulesh Chandra Borua, Arup Kumar Borua, again, 562, they have sold these portions of the land. So that is what I have mentioned in paragraph 11, and they have completely suppressed this fact. What was allotted under the Commissioner of Partitions return, my lord, irreparably they have been sold. So, my lord, they have parted with possession of their portion of Hawa Mahal allotted to them. Now they are questioning trying to dispose of my portion in favor of the state of Assam under the Commission of Partitions report. Then, my lord, paragraph 12. The entire facts as recorded aforesaid have been suppressed by the writ petitioners. Kindly, my lord, come to my note. The entire facts as recorded as aforesaid have been suppressed by the writ petitioner. What the writ petitioners have questioned is an alleged decision and release of compensation dated 19th October 2022 at page 80 of the writ petition, which is the final outcome of the above proceeding. After everything has been done, then, my lord, they have challenged that particular payment of compensation. On 17th October and 28th October 2022, writ petitioner objected to such proposal. And then, my lord, these objections have been considered, which I showed to your lordship. These objections have been considered, page 5 of my note, by the statutory authority on 8 December 2022, pages 201 to 203, by a speaking order. The said objections were duly disposed of by the statutory authority. Instead of assailing the said principal order, the writ petitioners have questioned the validity of the notice dated 10th October 2022, which has lost its importance altogether because of the above subsequent events. Such subsequent events have neither been mentioned, nor questioned, nor challenged in the writ petition. All the aforesaid incidents have happened before the writ petition was filed. And the interim order dated 9 February 2023 was passed by your lordship. Not to change the nature, character, and position of the property was passed. The said order was obtained by the writ petitioners by suppressing material facts. It is submitted that if the entire facts as stated above have been disclosed, the court would never have passed the order. My lord, the only I conclude my submissions on this by citing only the last decision on this. I have mentioned, my lord, already in that paragraph. I have placed before your lordship the second of the two judgments. My lord, the other judgment is 2007, 10 Supreme Court cases. Page 635. Flag correct. This is a short judgment of Mrs. S.B. Sinha. My lord, paragraph 11 and 12, perhaps. Para 11, learned senior counsel appearing on behalf of the respondent herein contend that the appellants before us cannot be permitted to take a different stand now, nor can they be allowed to play fast and loose. The High Court had arrived at its opinion only at their behest. Our attention on this behalf has been drawn even to the grounds taken by the appellant before us to contend that a writ of or in the nature of mandamus was sought for enforcing the purported legal right of the appellant vis-a-vis the state and its officers, and not against the private person. Such might have been the contention of the appellant before the High Court or before us in the special petition. But we have no doubt in our mind that the disputed questions regarding title to the properties of large number of churches could not have been the subject matter of determination of writ under Article 226 of the writ petition. And then, my lord, kindly come to this is, of course, on the issue of private law remedy. This is really titled to the property is being disputed. The property which has been allotted in my favor, which I am seeking to, my lord, give it to the state of Assam, that is being, my lord, challenged before your lordship. I say, my lord, this judgment which I am citing before your lordship is for the proposition that this kind of question with regard to title to private properties should not be the subject matter of a writ petition. And this is exactly what they have done. And this has been, my lord, condemned in paragraph 12 and 15. It says, for the reasons stated here above, we are of the opinion the High Court committed a manifest error in going into the disputed questions of fact, and also this regarding the dispute with regard to the rights of a particular group to manage the charge in so, my lord, that should not have been, my lord, the subject matter of a writ petition.
Mr. Mitra, are you reading 2007 volume 10 Supreme Court?
Yes, I think, my lord, that is what I gave there. 2007, 6. No. 2007, 6. Well, I think the wrong thing.
2007, 10. Yes.
No, actually 6.
That's why I was wondering.
Lordship.
My error.
তোমাকে প্যারাগ্রাফ তোমাকে ভলিউম 6 দেয়নি দাও ওটা ফেরত দাও ভলিউম 6 না this has got nothing to do para 7 and para 8 and then para 11 para 12 and the court said that the court should not interfere in an institution like this.
Yes.
Even I am told as late as in 2022, they are selling the properties allotted in respect to the HON'BLE in their favor. So, my lord, I submit to your lordship that this particular return of the Commission of Partition has been given effect to. And that is what, my lord, the state of Assam had taken note of in that order. That order is a very succinctly it has put. It has looked into the preliminary decree. It has looked into the return filed by the Commission of Partition. It has looked into the way the parties have treated these properties. And then thereafter, it said that there is no merit in the contention of the petitioners because the petitioners themselves have agreed to this kind of thing. Therefore, why should they? But all these facts should have been there before your lordship. In the writ petition, there is nothing. And only after, my lord, the state of Assam had come out with this. And we have, my lord, come out with our defense. But they have filed a supplementary affidavit annexing this. To, my lord, to, I should say, atone their guilt, if I may say so with respect. My lord, these are my respectful submission. I hope, my lord, these notes I have prepared will assist your lordship. আর কিছু বলবার নেই।
Yes. Please be a little louder, sir. I think another tomorrow. Let the petitioner reply to this tomorrow. We are on the maintainability issue. Do you have to add anything to this?
I have wholly replied upon, my lord, the state of Assam's affidavit in opposition. That affidavit in opposition, what has been annexed should have been annexed to the writ petition. That is my grievance.
My lord, may I make one submission? My respected senior had made some submissions on 6th of February. That order, unfortunately, my lord, is not available on the internet. 7th is available, but not the 6th.
Maybe 6th February order server হয়নি বোধহয় দেখে নেবেন একটু। ওনার হচ্ছে না 6th February অর্ডারটা সার্ভার হয়নি বলছেন একটু দেখে নিন। অর্ডার শিটটা দেখুন।
এবারে ফি গুলো বার করো। অনেকদিন ধরে আর্গুমেন্ট আছে, ফি গুলো বার করো।
একটু নামান নাহলে বোঝা যাচ্ছে না অর্ডার শিটটা
কিরকম নোটটা তৈরি করেছি।
6th February.
Not 7th February, my lord, it is available on the continue. I'm not sure whether any order was passed on 6th. I'm not sure whether any order was passed. That's why I'm just apprehensive.
6th February, no order was passed. I think it was made not today, I think.
No, my lord. My respected senior made submissions on 6th. On 7th, it was adjourned.
On that elaborate submission that's been made by you.
Well, kindly, have it.
Otherwise, kindly
Well,
record.
kindly have it recorded. Otherwise, I won't get my fees. They just won't pay my fees.
No, you are not appearing on behalf of the state.
No,
It's on behalf of the private respondent.
Private respondent.
So they will pay you in case.
Record for me.
You know.
Appearance recording.
On the jurisdiction point.
On 7th day, Mr. Mitro was also present on that day. Thereafter, it was at. Yes.
No order was passed on the 6th.
Kindly one line order to be passed otherwise.
Otherwise, to me, I'm a fees.
No, I understand.
It is a material, my lord. He does not appear. Because he is appearing on behalf of the private persons, my lord.
Naturally, yeah.
If the government is there, then question of fees, bill, etc. is involved.
No.
I guess that probably it was omitted, but if your lordship is not passed, so be it.
Please.
I shall argue on the my lord. I shall raise on the 4 points, my lord. Learned friend, because it is a,
Tomorrow we shall answer.
Our case, the writ petition, my lord, has a own checkered history of this, my lord. I will show you.
We are only on the maintainability issue. right?
Yes, I shall hear because I have already completed the arguments on merits, my lord. Thereafter,
I
they
am
have come.
supposed to deal
That
with
is
the
why I
first,
shall,
then go into merits.
my lord, first objection would be whether the submissions made by the learned advocate for as preliminary issue on 1811, whether it is sustainable or not in the eyes of law. Whether procedure of law as prescribed in our country has permits him to do so.
The
That
Supreme
is
Court
my
has said
first
that I
submission,
can
my
do that.
lord. That is my suggestion. His senior advocate appears, my lord. I have due respect to him.
Very well.
Procedure cannot be given by
ঠিক আছে কালকে
it is a procedural law. Whether he can bypass the procedure of law
Please
before
come
the
back
read court.
tomorrow, make your
When the
submissions,
read court
please.
entered into the merits of the
And Mr. Mitra will have an opportunity to reply.
Yes, Lord. Okay.
Yes. Right. Her learned counsel for respondent numbers 8 to 13 at length. Paragraph. Let the matter appear under the same heading tomorrow. That is kalke date din. For further consideration on the issue of maintainability.
We shall only answer, madam.
It is already fixed at 11:30. Agar order e tai ache na 11:30?
Yes.
It's already fixed at 11:30. No difficulty, no difficulty. Right. What a bracket for the 30.
Tomorrow at 12:30. 11:30. 11:30.
Yes. তাও ব্র্যাকেট আমি একটা অর্ডার যেহেতু করছি ব্র্যাকেটে কোনোটা মিস না হচ্ছে mention that
16.
mention that mention
But I appear on behalf of the petitioner.
service complete.
Yes, Lord, yesterday just I have
Yes,
started.
sir.
Kindly recollect, my lord. An application for mining lease has been made on 31st January 1995. But I have shown, my lord, at page, application start from page 29 till 31. 32, page 32, yesterday I have shown, my lord, that
Yes.
the receipt of the application. Now, why I have shown this? Because of this,
And
they
it
have
would allow.
because they have received this application and they have registered it in the register. But my contention is this: if there was any wrong, or if no documents are available or which is required to be produced, then my application should not have been or could not have been not registered in the registered book. So from these documents, I can establish that my application was not only they have received, but it also
This is an acknowledgement of receipt
Yes,
of the
receipt,
application,
receipt.
not consideration.
not consideration, not consideration.
So even a defective application can be received.
No, not received. It has been registered in the registered book. If it is defect, then could have been rejected.
This is an acknowledgement. of
Acknowledgement.
receipt, Nothing
Yes,
more.
yes.
Yes.
Acknowledgement receipt, and it has been recorded in the register. If it was not in accordance with law, or if it was not in order, then that could have been rejected at the threshold. Then since this application was not considered by the authority, the petitioners moved a writ application before the Honorable Court,
It's
and
36,
this
yes.
Honorable Court, page 36, kindly come.
Yes.
This is the order dated 27th July 1995. Now this order, my lord, the past, my lord, with page 36, the relevant portion. Now, there are three parts. Number one, the application for mining lease and the case as may be is to be disposed of by the authority concerned in accordance with law within a period of within 8 weeks from the date of communication of this order. So, my lord, this order, my lord, in accordance with law at the relevant point of time. Next, which is to be communicated by the petitioner within 2 weeks from the date. Now, second part is, while disposing of the said application, the authority concerned will not take recourse of Rule 7 and 7A of the minors minors rules. Now, 7 and 7A, the restriction was there. If the application has not considered within certain period of time, 1 year, then that should automatically that should automatically not go by, or shall I say the word refused or whatever may be. Now these guidelines, this provision, this protection has been given by the Honorable Court, directing the authority that you should not apply that provision. And third part is the interim order that has been given in my favor. Now, in the meantime, the petitioners will extract sand and gravels from the land in question on payment of royalty after extraction of sand, which will be assessed by the respondent. So, pursuant to this order, they are allowing me to extract sand from the riverbed on the basis of that application. So, order has been activated, or it has been given effect to on that score only. But the application has not been considered at all. Subsequently, I have annexed few documents as page 41, 42, 41 to 44. These are the receipts. I have the original the receipt with me. These are the receipts for I have extracted sand, I payment the royalty. Now, simultaneously, what happens subsequently, they have stopped us to allowing the extraction work, and they are want to give somebody's petitioners made application. A writ petition was moved before this Honorable Court, and this Honorable Court was pleased to dispose of the writ petition, directing to consider. They have, on the first day, the matter was adjourned, asking the authority what you have done. And on the second day, when the matter was taken up, the authority produced a documents saying that we have considered and rejected. But reason the opportunity was not given. Then the third writ petition was moved. Writ petition was allowed, directing the authority, you are not giving the opportunity, so you give the opportunity and take a decision. But that was not the rejected. Then I challenged it, that not the reason order before this Honorable Court, and my lord has been pleased to take up that matter and dispose of the writ petition. My lord's order at page 58. Their rejections were twofold ground. One, the reason order, as I have shown, my lord, the order passed by the Honorable Court, direction was there to communicate the order to the authority by 2 weeks. They say not communicated. So that was one ground. And second ground they have taken that
61, 62.
Yes, that 16 rules has been came into effect, so your application cannot be considered. Now, my lord has been pleased to dispose of the writ petition by setting aside the impugned order and directed them to take a decision upon giving opportunity of hearing. And I'm page 60, I am placing before my lord. What is my lord's view is there. Third paragraph. It appears from the documents produced by the petitioners that the copy of the earlier order of this court was duly communicated by the petitioner to the authority also. Also, the order impugned is bereft of any reasoning with regard to the scope of entertaining the application in terms of the earlier and existing rules. Learned counsel for the state respondents also submit that the matter may be remanded to the concerned authority for reconsideration. In view of the above, the order impugned passed on 5th March 2019 by the additional district magistrate and district land and ransom officer Paschim Medinipur is set aside. The concerned authority, being the third respondent, that is the district land and ransom officer, is directed to revisit the application and pass a reason order and reason and speaking order upon considering the submission made on behalf of the petitioner, his authorized representative, as well as the provision laid down in Rule 61, 62 West Bengal Miners Mineral Concession Rule 2016 and Rule 40 of the West Bengal Miners Mineral Rules 2002. The authority is directed to communicate the order to the petitioner within a week thereafter, the writ petition will be disposed of. Now, decision has been brought that they have given an opportunity, the hearing was made and the reason order has been passed. Reason order is under challenge in this writ petition. The reason order start at page 75, bottom portion can you see that is the date of the hearing. The order number 2 dated 12th of May 2023. Today, the Hazira is not required. Next page. In the course of hearing, the petitioner submitted a written notes of argument which is also taken into consideration. The main issues to be taken into considerations are, number one, my lord, the petitioners claim to have submitted an application for granting LTML, long-term mining lease, which has not been considered. Then, the petitioner is also to revisit considering the submission made on behalf of the petitioners, his authorized representative, as well as the provisions laid down in Rule 61 and 62 of the West Bengal Miners Minerals Rules 2016 and Rule 40 of the West Bengal Miners Minerals Rules 2002. Then the application was made in the year 1995 and should be considered as per West Bengal Miners Minerals Rules 1973. These are 3 points they have formulated. Now, decision has been taken. Can you see what is decision? The fact is the petitioners claim to have submitted an application for granting mining lease for minor minerals, sand and gravels in terms of rule in Form A, addressing to the Secretary, Commerce and Industries Department, Mines Branch, Writers Building, Calcutta. 1. Another copy of the Form C, addressing to the Office of the Mining Officer in charge of Purulia Zone, Purulia, was annexed in the writ petition, who is not a party in respondents. But during the hearing, no such original received copy with the office seal and receipt signature of the office concerned with the date thereupon has been able to submit by the petitioner. This is the wrong statement. I have the original copy. I along with me. Then the petitioners hereby cannot hold any right to do sand mining without his lease deed or quarry permit or license as admitted and granted by the competent authority, nor any copy of the acknowledgement received of application form granted any right to the petitioner to mine sand from the land in questions noted in the margin alongside. Hence, the claim for long-term mining lease in this regard is not admissible. Now, this is their stand. Then, not the very peculiar, I never heard this. No application is specific has been submitted by the petitioner after the order of the Honorable High Court, Calcutta was passed in connection with the case number 30. Not at all necessary. Except a written notes of argument submitted at the time of hearing conducted. Hence, the contention as heard on may be considered in the ambit of existing statute. The Honorable Court has, in specific order, to revisit his submission under the provision as laid down Rule 40 of the West Bengal Miners Minerals Rule 2002. Pursuant to Rule 40 of West Bengal Miners Minerals Rule 2002, West Bengal Miners Mineral Rules 1973 has been repealed. I will show that part. The fact is that the lease application to the mining officer or chief mining officer must be accompanied by a valid and up-to-date clearance certificate of payment of mining dues. Number 1. Number 2, Roman 2, income tax clearance certificate. Roman 3, sale tax clearance certificate or otherwise as claimed and produced on the part of the petitioner as to whether any action or proceeding was started as laid down under the West Bengal Miners Mineral Rule 1973. So here 3 parts, 3 points they have taken. Number one, they need that up to date income tax clearance certificate, sale tax clearance certificate, and clearance certificate from them. But as per the form, I am placing that I show the form. And they say that apart from that, any action is taken or not as per 1973 rules. I have already shown, my lords, that 4 receipts are annexed there. So action has been taken, they have accepted the money, and they are allowing me to extract sample. So action was taken by the authority. Next, which license, but no documentary evidence in terms of proper receipt copy bearing mandatory annexure accompanied by the lease application is submitted. Again, my lord, wrong statement. I have the receipt, original receipt copy. In that receipt column, probably my lord, column number 21, 22, 21, 22, and 23. These 3 documents are indications are there. In addition to, as per sub-rule 2 of 62 of West Bengal Minors Minerals Concession Rule 2016, the West Bengal Minors Minerals Rule 2002 has been repealed, which came into force on 8 November 2002. But that I will show from the document from the rule. As a matter of fact, the said documents of the year 95 do not come under the purview of West Bengal Minors Minerals Rules 2002. So their contention is that Rule 73 or 2002 will not be applicable. Hence, the claim of the petitioner's right to grant of long-term mining lease to mine sand from the land in question is not admissible as per existing statute. Next, in pursuance of West Bengal Minors Minerals Rules 1973, application for mining lease is submitted to Chief Mining Officer and the query permit is issued by the district authority, that is additional district magistrate or additional deputy commissioner in charge of waste acquisitions or land from in the district. Pursuant to rule, this is wrong quotation, 21.4.1 of the West Bengal Minors Minerals Rules 1973, an application for mining lease should be disposed of within 1 year from the date of receipts. Otherwise, it is deemed to have been refused. Now, this is the harming, this was protected by the Honorable Court. I have already shown that Rule 7A and 7A. That protection already granted to me. Honorable Court says you do not imply that part. So my application cannot be said that it has been deemed diffuse. Cannot be said. Provided that the state consider any extension to the feet and deserving as laid down in the statute under West Bengal Minors Rules 1973, the application, if any, deems to be cancelled. Hence, the application made in the year 1995 being considered under West Bengal Minors Rules 1973 is not accepted either. Their contention 73 rules cannot be applicable. In the light of the above observation and view of the discussion following the issues framed, all the contention of the petitions have comprehensively been heard and considered, but rejected in the ambit of the statutory provision following the order passed by the Honorable High Court, Calcutta, and thus the instant case is disposed of, plain copy suggestion. So they have rejected my application. They have taken the point which are not at all applicable. Very frivolous ground they have taken. The legal point they have taken, 1973 rule will not be applicable in my case. And they also says that I am unable to produce these 3 documents. Number 1, clearance certificate from the department. Number 2, the income tax and sale tax. And number 3, they say that I could not produce that any action has been taken pursuant to the order of the Honorable Court. I have also annexed here the documents which are earlier annexed, the documents from such. The next page, Lordship, kindly see, page 78. This is the income tax clearance certificate I have annexed in the in the application 78 and 79. Then 80, my lord, 80 and 81, this is the commercial tax, that is the sale tax documents. I have also annexed. Page 82, this is the, my lord, the affidavit. There is an alternative, my lord, the alternative documents are there. Lordships can come page 30. 30.
Yes.
Column number 20, paragraph number 20, 21 and 22. 20, the number and dates of income tax clearance certificate from the ITO, income tax officer, copy enclosed, they are written copy enclosed. Then 21, similarly, the clearance, that is the affidavit. So far the clearance, mining clearance, because no work was done previously. So question of clearance does not arise when the application was made. That's why the declaration for affidavit enclosed. And 22, the sale tax clearance. They have acknowledged this application and registered in the office, registered. On the ground, on the reason is there, because all these documents are there. Otherwise, if it was not there, it was automatically cancelled. They have not said though. Now, my lord, your lordship's last occasion directed my landed friend to file a report on this. They file a report and I file also, my lord, exception to that.
Will you continue some other day? Because a lot of matters are waiting. I want to dispose of a few shorter matters.
Not just or
Because I think
or
Mr. Dev
10
will also
minutes.
take some time in this matter.
Not what 10 minutes I can finish.
Lot of
tomorrow.
other matters are waiting actually. That's why. Continue some other day.
Tomorrow. But this.
Yes.
After tomorrow as a date, making the date.
I'll give a short date.
Let it be in the list with the date, so that nobody will mention them. I need not to mention once again. If you lordship pass the order, then matter may go down. It will come under the other heading. I have then again mentioned. This was the twice I have mentioned the matter, and your lordship has been pleased to fix under the heading mention matter. Let it be in the list with the date, subject to convenience to my lord. না এটা তো হয়েই গেছে শুধুমাত্র আমরা
You want to come? You want to file an affidavit? I don't think it's necessary.
Report is there, exception there on the basis of
some time. That's why I want to heard learned counsel for the petitioner. Paragraph same heading here. Let the matter appear under the. I'm keeping it under the same heading. Under the same heading on. Next Monday, 26th.
And yours. Same heading, my lord, it will take another.
26, that's right.
26.
My lord, in 654, learned counsel Mr. Nilanjan Bhattacharya is appearing for Union of India, my lord. But due to an accident occurred, my lord, he got admitted in the Appellate hospital on last Saturday, my lord. My lord, his leg has been fractured. Right leg has been fractured badly. My lord, I'm paying for an accommodation for fortnight, my lord.
You're enjoying an interim order, let that be.
There is, but there is some urgency, but on this ground, I really can't oppose. My only humble request would be if it could just retain its position, my lord. After 2 weeks, we'll come back, and by then, if he's back, then we'll come back.
I'll extend your interim order.
Very well.
Because I don't think I can accommodate you in February. So the interim order is still 29th February.
29.
On prayer of the Union of India, the matter is adjourned. Paragraph, let the matter appear under the same heading on 14th March.
Very great.
Paragraph, the interim order granted, same heading, under the heading motion. The interim order granted earlier is extended till 31st March or until further orders, whichever is early.
Grateful, ma'am.
Lord, would it require a separate direction from your lordship that will retain its position?
it will retain. Let us see.
That
Since
one,
like all the
I will.
privileges cannot be granted. I've
Very
extended
well.
your interim order. for
Very
example.
My lord, I am for the petitioner, man.
Yes.
On last several occasion, your lordship directed the state to submit their report, my lord.
Yes, Mr. Dey.
Item one represented. That will be considered by the authority. Then my lord, it is clear. And because my lord, according to them, my lord, that is the actually my lord, they wanted to that the land was acquired, but practically land was not acquired. But the municipal corporation was proceeding. The land and my lord used that the land into power. Only for that is my lord, that will be considered by the authority, and the authority will how they will take the land, got the land, my lord, that is a very important. The corporation will say.
My lord, it is clear, my lord, from the that KMDA. Acha, sir.
KMDA has submitted a report, is it?
Yes.
Yes, we have
So
submitted.
it says that it has been utilized.
No.
No, they have not acquired.
In our report, if your lordship kindly sees paragraph 6 and 7,
Yes.
we are not in a position to make it clear because we have the records corresponding to RS DAG number. The petitioner, what is claiming that is in respect of LR DAG number. So we have written to the state authorities, lordship will find at page, the letter lordship will find at page 8 of our report, requesting to inform us the corresponding LR DAG number of the RS. Corresponding RS DAG number of the given LR numbers. We are yet to receive this information, so we are not in a position to say, and the allegation is not against the KMDA. Allegation is against the Howrah Municipal Corporation, paragraph 6 of the writ petition. Paragraph 6 of the writ petition. So, paragraph 5 and 6. 5 and 6. So, Howrah Municipal Corporation can throw some light at least.
So my lord, you will consider the representation. How you will got this land, my lord, and that a path of
No, yeah, ওখানে তো হাওড়া HMC against it.
KMDA has not actually acquired the.
No, nothing.
My lord, your lordship will
it is not
kindly
the
come to
allegation
page 33 once of the writ petition. This is the adjacent plot, my lord. Your lordship kindly find the address 18/3. My lord, the KMC has, my lord, HIT, Howrah Improvement Trust, with reference to your letter, I am directed to inform you.
It is not under acquisition or
Yes.
possession basis. Yes.
Thereafter, my lord, the HMC has come into, my lord, taken that land forcefully and made the pathway.
So,
My lord, then, my lord, direct the Howrah Municipal Corporation, how they have taken the land without acquisition. He is appearing.
Howrah Municipal Corporation should answer.
ওটাও জানেন।
No, it HMC against allegation. First of all, HMC
Filed by you.
let the HMC say.
Let the Howrah Municipal Corporation come back with a report.
Yes, that is needed.
or my lord, they will be considered the representation.
That will not help in this matter, Mr.
That-
because it's
that may not.
not that simple.
Yes.
Because the petitioner will not get any relief.
First of all, HMC has to make
But this
clear.
is a tussle between the authorities.
Yes, my lord. My lord, since, my lord, long time, my lord, we are moving here and there. My lord, petitioner is also a senior citizen, a handicapped person.
Page 30, what is shown, the information supplied by the HIT. Now the HIT has been merged with the KMDA. So HIT, since the HIT says that that is not, the land is not involved.
Let the Howrah Municipal Corporation come with a
Yes,
report. And even the state, I should say, because several extensions have been.
My lord, state, my lord, if the land was not acquired, how the state
report
will find the report that that plot was not acquired by us? Only for that, my lord, I have nothing to say in this matter.
So you don't want to file any report at all in this
As
matter?
because, my lord, only for that reason, my lord.
Learned counsel for the state respondents submits that the state does not intend to submit any report in this matter. Learned counsel for the Howrah Municipal Corporation seeks to submit a report in the form of affidavit. Please submit your report in the.
One information at page 31 of the writ petition,
Yes.
the special LAO Howrah says, the last line, the information is not readily available. That information is not available with the.
Land record.
Let them come back with the report. Let us see what the report
Sure.
says.
Yes,
Because mere consideration of representation will not help in this matter.
may not.
Let the matter appear under the under the heading motion on 21st March should be sufficient for you.
My lord, let the matter be placed, my lord, under heading to be mentioned. Otherwise, my lord, it
No,
will.
why do you mention?
How? It needs to be heard.
My lord, he is senior citizen, my lord. Again, I have to mention the matter, my lord. Kindly consider only this. My lord, I am moving, my lord, here and there since 30 years.
Sir, shall I give
He
you a
is
list
also
of-
present, my lord.
Shall I
before
give you a list of the senior citizens matters which are pending before this court? Let
This is
it
my
appear,
prayer,
let them
my-
come back, let them come back with a report.
Hey, Dada.
My lord, let them serve a copy prior to that.
Please serve advance copies. Yes.
What the petitioner, my lord?
Mr. Owen Banerjee is for the state respondents, my lord.
You're appearing for the petitioner?
Petitioner.
Yes, what is the matter about?
My lord, the petitioner has a quantum of landed property measuring about 61 decimal, which is lying and situated at plot number 1, various plot numbers, plot number 1, 1/805, 1/806, 1/80812 at Chokbadalpur Moja, Paschim Mednipur, my lord, Sabang districts, under Sabang PS, my lord. My lord, the PWD department, without giving any single intimation, any knowledge, has acquired the land of the petitioner and made road construction, which is going through Bungu Chowk to Potaspur, my lord. The petitioner, my lord, at first made an RTI application dated 9/9/2021, asking about whether her her land has been acquired legally in any LA case number or not. In the reply, my lord, and I kindly come to page number P2, annexure 25, my lord.
Page number?
Page number 20, running page number 25, annexure P2. I'm reading it out, my lord. The plot number 1 of Moja, Chowk-Badalpur, jail number such and such appears to have not been involved in LA case number such as mentioned in her petition, my lord.
Yes.
Therefore, my lord, the petitioner made an application before the BLRO, Habong, asking for recognition and demarcation. Accordingly, my lord, the BL and LRO form a team of government, and an executive engineer and ask them to submit a report, my lord. Accordingly, my lord, the team made a survey and submit a report, my lord. Kindly come to annexure P4, page number 27, my lord. There is a report, my lord. Particular portion there is, my lord.
Yes.
Line number 7, my lord. I'm reading out. The information of the LA department reveals that any part of the plot number 1 of Moja,
27, you said?
page number 27, my lord, annexure P4.
Yes.
Report, my lord, submitted to the BLRO. Line number 7, my lord. The information of the LA department. May I continue, my lord?
Yes.
The information of the LA department reveals that any part of the plot number 1 of Moja, Chowk-Badalpur, jail number 174 is not acquired via the department's memo number 468 dated 9/9/2021 in spite of kindly take a look, my lord. In spite of non-acquisition of any land over the plot number 1, a line over the LR Moja map has been drawn as per Amin's plan supplied by the LA department, acquiring a part over the plot number 1 in favor of PW department. Plot number 1 is the petitioner's plot. Thereupon, my lord, the BL and LRO make forward a letter as per this report, my lord, forward a letter and asked the assistant engineer Kelaghai Bridge Highway Subdivision PWD Department, Balichak, Paschim Manipur to take action. Till now, no such action has been taken yet. My lord, page number running page number 33, annexure P7.
Yes, so you're asking for compensation.
Yes, my lord. For your satisfaction, your lordship, I would like to kindly come to page number 29, my lord. With the report, such report has been annexed by that particular government, Amin, and executive engineer after making survey. And there is a line
Page number?
dot page number 29, annexure P4, page number 29.
Yes.
And there is a line dot. Such portion has been acquired, my lord. My prayer before is then, my lord, we have made application before the DM. Copy forward to the LI department and my lord the PW department.
Page 35?
Page number 34, annexure P8, my lord. My prayer before your lordship.
Yes.
I want to get compensation from the particularly department, PWD, LA department.
Yes.
As per market rate.
Submission on instruction, let the representation made by the petitioner be considered by the competent authority and a reasoned order be passed within a time period as may be fixed by your lordship.
Reasoned order within 1 month?
Within 1 month.
He is entitled to compensation within another 2 months.
Lordship.
It will pass.
Affidavit of service. Third learned counsels for the parties. Paragraph, it is contended on behalf of the petitioner that the petitioner is the recorded owner of the plot in question and a plot in question which has been utilized by the respondent authorities. The PWD Midnapur has utilized.
Yes. Respondent number 6 and 7.
By the PWD, Midnapur by constructing a road thereon. In reply to an application made by the petitioner under the Right to Information Act, she was informed that the plot in question was not acquired. The plot in question or any portion thereof has not been acquired. Survey of the plot was conducted by an Amin appointed by the Block Land and Land Reforms Officer, Shobong, Paschim Medinipur, and upon demarcation, the Amin, by a letter
report.
The Amin submitted a report by submitted a report before the Block Land and Land Reforms Officer, Shobong, Paschim Medinipur, stating that though the plot in question is not acquired, comma, a line has been drawn over a portion of the said plot in the LR Moja map, and a concrete road is running through government land as well as a part of the plot in question. The petitioner submitted a representation before the District Magistrate, Paschim Medinipur on 7th December 2022, seeking compensation for utilization of her land. Stop. The said representation is yet to be considered. The petitioner prays for a direction upon the concerned authority to consider the representation at the earliest. Paragraph learned counsel for the respondents submits. The DM shall consider
Yes, ma'am.
that the second respondent, yes, be directed to consider the representation in accordance with law. Paragraph in view of the above, the writ petition is disposed of, directing the second respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph, in the event the petitioner is found entitled to compensation, comma, such compensation shall be disbursed in her favor within 2 months thereafter.
Straightforward.
I'm deeply
Disposed
obliged,
of.
my lord.
Cheers.
Next.
I am for the petitioner.
I am for the response.
Sir, this is my lord admitted fact. The petitioners, the land used for cultivation, the adjacent land has been used by the respondent for establishing a thermal project. Now that has been affected, and as such, the respondent started paying the compensation. Now, since 2015, we have received. Now, thereafter, for not receiving, the petitioner preferred a writ petition, challenging a
For not
for
receiving,
non receiving the compensation, because they used to get year-to-year basis the compensation. Now, there is a direction by the Honorable High Court to consider the representation. So thereafter, the representation has not considered. Now, there is also a subsequent writ petition. A contempt proceeding has been filed. My challenge is very limited, my lord. They have passed an order stating this is a last page order. What they have filed, because there are 119 petitioners are there. And I will show the names also reflect in the list of compensation also. Now, what happens in the last page, page number 111,
so since 2015, compensation has not been granted.
not been granted. Now, what they say in reply, page number 111, the second part, the compensation has been paid to the stakeholders, which period not mentioned. An affected land barring the land already acquired by the irrigation department. Thus, the matter is disposed of. My lord, I say this is a vague 111. The second part. I say this report is vague, my lord. There has to be a comprehensive and detailed report, because there is a order passed for recent order. There is no mention of date, how many persons have received, when they have received, nothing. That is my only grievance.
Yes.
There is no scope for any interim order, so the direction to filing affidavit.
Not
there is
necessary
time.
at
Let
all.
them file a report.
Why
File a
affidavit?
report, yes, not file a report.
It needs a
Because the
reconsideration, sir.
petitioners,
Why
you
even
know,
report?
what happened, my lord, as I have been instructed, my lord, because I have not seen the papers, my lord. Because what happened, my lord, that the compensations was paid, my lord, upon the verifications of the title of the lands. And the petitioners, those who are not having the proper title of the land, they are not giving compensations, and whose land was acquired by the waterways and the irrigation department. In those cases, compensations was not been given. This was the case, my lord. Only, my lord, the name of petitioners has not been mentioned in this order, and during the period, my lord, has
I'm afraid nothing has been mentioned in this order.
yes, my lord.
Not only the name. What is the
See-
period of compensation? Nothing
Yes,
has
Lord,
been
yes,
mentioned in the
yes,
order.
yes, that I agree.
Why don't you reconsider this and
Pass a.
pass a recent order? Yes.
No, it is better not. We are ready to pass an order. If it is passed, this order will not stand. This order, if it is passed once again.
The same order will be
So
passed.
let it be not decided. Yes, I'll file a report, Milord, and your lordship. will
Milord,
decide
because
the
I
matter.
say, Milord, I have
Otherwise,
annexed
your
the
lordship.
list on 2011-12 only. Well, kindly page number 61.
Let learned counsel come back with a report.
I say because the names are there. We have received compensation. Now that this plea cannot come now that you are not entitled to because of the title.
You have paid till 2015.
Yes. So, Milord, this
That is-
title cannot come up
yes,
as a reason
There should
for
be
not giving.
reasons for it.
Definitely. That in the report I'll mention. Milord.
Heard learned counsels for the parties. Paragraph, learned counsel for the respondents is to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear under the heading motion on 22nd March.
Milord, one indulgence,
serve an
let
advance
them
copy.
supply the survey report also, Milord. That will help the petitioners because has to be a survey and that has been done.
Why a fresh survey is necessary?
No, fresh survey. No, the survey report, what they have done. No, I'm not saying to make a survey. There was already a survey has been done. I'm saying that reports shall be annexed in that report.
Yes,
That's
Milord, that who are the entitled, Milord.
the earlier survey
Who
report.
are entitled, Milord, definitely that will be
Please
reflected
give
in
us
the.
file a detailed.
Yes, yes, yes.
Grateful.
Of course.
Grateful.
State has also. State also has to be
Report in the form of an affidavit.
by both Milord, state as well as DVC or. Milord? Because
I think
they
it
are-
would be better if you file if you
And
also
because the
file.
waterways department also will not
Fine.
acquire the land. So there is also some.
Is the next matter short?
Yes, yes. Very short matter.
Ikrar.
Milord, here is the affidavit of service. All respondents are. Milord, the petitioners and the private respondents are co-owners of a land. Now, Milord, in front of the ingress and egress of the petitioner's land, the private respondents have enclosed the PWD land and they made a temporary construction of a chicken shop. And my lord, they are also trying to construct a pakka building there. So my lord, absolutely blocking my ingress and egress of the petitioner's portion of the land. That's why, my lord.
Serve the private respondent.
Yes, my lord. My lord, also I have served them upgradation letter
There are
also.
Postal receipts. Was anyone appearing for the private respondents earlier? No.
No. It's the first time it's appearing.
Yes, where is your representation?
Ma'am, representation at page number 21.
Let this be considered.
Let us become.
Yes. Do you have anything to submit?
I have a report submitted by the police station. Get a copy.
Officer in charge. What has he got to do with this?
According to this report, the respondents and the petitioner both are the co-sharer of the property, and where the construction is going on, the respondent and petitioners are. Finally, come to page number 2. Page number 2 of the.
Yes, exactly. The police authority has no role to play at the moment. Yes.
Complete civil dispute.
This is not necessary, sir. The report of the police authority.
But kindly give a specific time period.
Absolutely. Yes, police authority's report will not be accepted at all. What role does the police authority have and who has directed them to? Has the court directed them to file a report?
No.
The court will never direct the police authority to file a report in a writ petition. What if it affidavit of service, none appears for the private respondents despite service. Paragraph, the petitioners claim to be co-owners in respect of the plot in question, along with the private respondents, and submit that the private respondents are trying to raise unauthorized construction by encroaching upon a portion of the PWD road adjoining the petitioner's property, thereby obstructing their egress and ingress. The petitioners authority to consider the representation at the earliest. Paragraph, learned counsel for the state respondents submits that the third respondent should consider.
Third respondent, my lord. Yes.
The third respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the writ petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioners dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondents, in accordance with law. Disposed of which actually.
Next matter, on consideration of representation by the
I have got the state.
Next matter.
Yes, madam. No, yes, madam. Yes. Only
if
consideration.
possible. Only consider.
Here interview.
Next matter.
Yes. My lord.
Only consideration, my lord, by DM.
Affidavit.
Number 2.
Page 27, my lord, my representation.
My lord, that is.
Private respondent constructed their room similar on the government land. That is why, my lord, petitioner.
SDO.
No, yeah, DM, my lord.
DM, my lord. DM will consider that.
62
Yes. Yes, my lord.
1962 Act.
1962 Act is, my lord. Otherwise, my lord. DM will consider the representation, not in any act, my lord.
Page
As
27.
because, my lord, that is in the embankment, land of the embankment, my lord. Yes, only for that reason, my lord.
Irrigation department.
Where is your representation?
Page 27 and 28. Page 27 and 28. There is a nursing college, nursing institute, and hostel, in front of
Embankment, my lord. We may not want to allow anybody to stay in embankment, my lord. That so we consider that representation. My DM will consider that representation.
The obstruction has been made on the embankment.
Yes, my lord. In front of the nursing college and nursing hospital.
The affidavit of service, ma'am. Have you served the private?
Yes, my lord. Yes, my lord. Yes.
None appears for the private respondents despite service. The petitioners claim to be the recorded owners of the plot in question and proposed construction
No, that was constructed. Last year it was.
and runs a nursing school and college.
Yes, my lord.
Nursing school and
Yes, my
college.
lord.
And runs a nursing school and college therein.
And include hostel also. Hostel also.
Nursing school, college and hostel. The school, college and hostel therein. Stop. The petitioners complain that the private respondents are trying to raise unauthorized construction on the embankment of
government land at plot number, first page, my lord, subject matter, my lord, plot number 527 and plot number 1258 within Moja Kismuttala, and my lord, plot number 234 and plot number 167 within Moja Dig.
Oh, on government, let me record it as
Yes,
government.
government.
On, in back and KTB, on a portion of the government land adjoining their property, comma, thereby encroaching on comma, thereby obstructing the smooth functioning of the college. Stop. The petitioners submitted a representation in this regard before the concerned authority on
5th June, my lord, 5th June 26,
2023,
23.
which is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the state respondents submits that the second respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the writ petition is disposed of, directing the second respondent to consider and dispose of the representation submitted by the petitioners dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners and the private respondents, comma, in accordance with law. Disposed of, which are
Grateful.
indulgence, my lord. This is very important matter, very urgent matter, my lord. My lord, item number 781 and 782 of today's list. I am for the petitioner. The National Highway, the respondent has already given me the notice and I shall be homeless. They will demolish my house. I have already mentioned the matter and it is already in the mentioning matter list, after mentioned matter. But it is too below that it has been any date is not reaching.
Matters cannot be done.
Kindly, my lord, it is fixed, my lord, or upgrade within top 10 or top 5, my lord. I shall inform the other side during the course of the day, my lord. Kindly, my lord. I shall be totally homeless. 781 and 782 of today's list, my lord.
দিদি এই দুটো একটু উপরে দেখি করে দিন
781 and 782. My lord, kindly keep it top 5 or top 10, my lord.
Let me see.
And 782 of today's list.
প্রথম 10টার
I
মধ্যে
shall inform to the other side during the course of the day, my lord.
প্রথম 10টার মধ্যে রাখো
ঠিক আছে My lord, grateful, my lord, grateful, grateful.
But I am for the petitioner. Yesterday, my lord, I have received one order. The basis of the hearing dated 6th of February 2024. But most surprisingly, the order itself is completely wrong and beyond the diction of my lord's order. My lord, kindly come to page 24 of the order, impugned order passed by my lord. Page 24 of my contempt.
Thank you. এটা দিয়ে দিন।
Yes.
By press representation at page 29 of the writ petition. My lord, in this order, there is no whisper regarding the press representation and facts of Shakti Pada Jana and nothing more, my lord. Kindly go through the order passed in this on 6th February 20.
Where this order has been
Order is complied with.
My lord, kindly.
This order has been complied with.
Compliance. Where is the affidavit? Affidavit of compliance. This is a contempt application. There has to be an affidavit of compliance.
I shall, my lord.
Where is it complied with this order? 6th
Yes, yes, my lord.
Kindly go through the order.
Mr. Debra, please show me one line that the representation 9th June representation has been disposed of.
Yes. My representation at page 29 of my writ petition.
Yes, not here, but everything was considered.
Nothing was considered, Mr. Debra. I'm sorry to say this. The court has already held that the petitioner stands on the same footing as the person who was granted earlier. So the authority could not have exercised an option. The authority had to grant the permit, simply.
The difficulty is on whether the Appellate is posted. Appellate, my lord.
The order
I do
has not
know.
been complied with.
No,
So
that is, I bow down your service.
please see the order under contempt. July 25, 2023 order.
File.
similar prayer of Shaktipada Jana was allowed.
Same route, man.
Same, it is observed in the order.
Yes.
The authority has no choice.
No, no, right. No, no, I'll come back, my lord, further.
And there is not one line saying that this representation was taken
Represent-
effect
that has to be there.
for
That-
consideration at all.
That has to be
Because,
there.
in the earlier order, though direction was for consideration of the representation of 9th June, the authority very conveniently considered the earlier representation. So this is the conduct and issue.
No, 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 that's not. I will come back with the phrase.
Let them come back.
Yes.
Learned Counsel for the alleged contender seeks further accommodation to submit the affidavit of compliance. Paragraph, let the matter appear under the. Mr. Debra, please give necessary instructions that when the court has held that the petitioner is on the same footing and the order has not been challenged in appeal,
Yes.
they have to comply with the order. They have no option left.
They have no option to it.
Yes,
Unless it is challenged,
it has not been challenged,
nothing.
so they have to comply.
I have to see the order because I have not seen. Today morning I got this.
Please give them necessary instructions. And let the matter appear under the same heading on 12th March.
Instead of 12, that is before 9th, ballot, that is better. Between 9th to something, I can make it medically check.
So can you come back on 8th March?
8th March. 8th March I will be there.
Interfere of me. Next.
Deeply obliged. Huh?
And if it's a jurisdiction, we obtain the prototype certificate under Rule 126 of.
Gracias. Hola, chula, chula.
By next month, the January 59.
Oh, it's the same prayer.
Same prayer and latest just before this matter, this water.
This is not the order. You've challenged both the memos. This is not the order. This is not the relevant order. Here only the 13th January order was challenged.
13th January and 17th January, 17th July.
See, please. Please see this.
13 January.
You've here only the 13th January order has been challenged, not the 13th. Joint তো আজ ই-রিকশার অর্ডার আছে না আপনার কাছে 13 জানুয়ারি আর 13 জুলাই অর্ডার চ্যালেঞ্জ করে যে অর্ডার আছে না আপনার কাছে করে নিতে পারবেন তাই
আরে কারেন্ট অর্ডারটা দাও না
I'll dispose it off. I
ডিসপোজ করে দিয়েছে তো
Mr. Khan, similar order will be passed. This is not necessary. This is not the order.
much obliged
13 January আর 13th July দুটো করেছে চ্যালেঞ্জ করেছে দরকার হলে আমাকে একবার দেখি না বাকি করুন না সেটা আমি চেক করবো ওই দুটো থাকবে সেটাতে
নাম দিয়ে দিয়েছি
অর্ডার 1 রুল 10 আছে ওটাতে দেখবেন অর্ডার 1 রুল 10 আছে
but she is appearing for the private
necessary order will be passed.
okay.
Next.
Next one, proceeding. 13 Germany and annex bill number 53 and 13 July, what place?
Same one. This 800?
Before going to the merits of the matter, may I just draw your lordship attention?
Affidavits were called.
Yes, there was a direction to file.
Are you ready?
No, kindly, extend the time, next time, innocuous prayer. No, whatever the innocuous prayer, there was a direction because he has challenged an order passed by the director. And that order was passed in pursuant to an order of this court. Now, that is a reasoned order at page number 57. Now, that order has been challenged. So, my lord, affidavit is required.
No, there is already a direction.
Already.
Let it come. 2 weeks.
Maximum.
The court has of 2023 August. Now, my lord,
The direction was on the last occasion, November 2023.
29 November.
Direction for affidavit.
And he filed a supplementary affidavit also. So I have
Learned counsel for the state respondents seeks extension of time to use the affidavit in opposition as sought. Paragraph affidavit in opposition we filed within.
only prayer, only one line order. If a lordship kindly, my lord, add this that the affidavit in opposition be a composite affidavit in opposition, because in the meantime he filed and upon me a supplementary affidavit. The earlier order was, my lord, that to deal with the original writ petition. Now a supplementary affidavit has been filed.
No. It is not recorded that you can only deal with the original writ petition. You can deal with all that you have with you. It has to be comprehensive. And when was the supplementary affidavit filed?
but this has been, my lord, it has been filed. I think so, my lord, last of it.
18th October. So it was filed prior to the order directing affidavits. Mr. Sen.
My lord,
yes, my lord, that order passed by my lord Justice.
Yes, order passed on 18th October.
My lord,
Very good.
Chaudhary has passed
Not-
the order.
The
We asked
direction is after that.
we prayed for filing of supplementary affidavit to dispose of all this. So thereafter, my lord, 18th October.
Yes.
Thereafter, the direction for filing of affidavits was.
Yes.
Affidavit in opposition be filed within 3 weeks from date. Stop affidavit in reply, comma, if any, comma, be filed within a week thereafter. 3 weeks and 1 week to March. Monthly list of April.
This is, my lord,
3 weeks and 1 week, 1 month.
তুমি তো reply দেবে তো।
let it be month, not in the monthly list. Whatever your lordship fixed date, but not the monthly list. Well, monthly list matters.
I have to actually keep it out of list. Because affidavits are not complete.
Then I mentioned this matter. Your lordship direction was to liberty to mention.
I'm not sending it out of list. I'm keeping it in the monthly list.
Let it be in the
Arre,
not
হয়ে
in the
যাবে।
monthly, any date. Even in April, your lordship thinks so. Then any date.
I cannot fix a date because
Your lordship kindly
so
appreciate
let it go out of list in that case.
মেনশন করিস না, আমাকে একটা নোটিশ দিয়ে মেনশন করি না, অসুবিধা কি আছে? আর্জেন্সি কি আছে?
Let the matter go out of list for the time being, liberty to mention.
বেশ তাই করিস। Get it.
Next.
No, I'm appealing for the state respondent in this one.
Lordship, on the last occasion, Jharkhand government was directed to file an affidavit in this matter, Your Lordship. I'm seeking for some time, some more time to file a counter.
Report in the form of an affidavit.
Yes, Your Lordship, the report.
There was a direction upon the state transport to West Bengal also, my lord.
Yes.
And in the letter, my lord, in response to the letter, my lord, of the STA of Jharkhand.
No,
Post
direction was upon the Jharkhand authority only,
Yes.
but
No,
the
the
state said that you will reply to the letters issued by the Jharkhand
Lord,
authority.
I have already talked to them, Lord, but the person concerned who is on leave now, so it couldn't. I will in the next day when my learned junior friend will send on the next day I will submit.
Learned counsel for the State Transport Authority Jharkhand seeks extension of time to submit the report in the form of affidavit as sought. Learned counsel for the state respondents also seeks to submit our report in the form of affidavit on the adjourned date. Paragraph, let the matter appear under the. Please try and serve advance copies to Mr.
Lordship, I will serve the advance
Agreement
copy.
is specific on the last day I argued before your lordship, but your lordship's only clarification of that, the reply to be given
Your
by the
only
state.
issue is non-compliance of 2H of the
2H,
agreement. That is the only
Yes.
issue.
Minor.
Yes.
Sorted, my lord.
13th March.
13th March.
I'm deeply obliged.
Next.
Matter, my lordship directed me to file a report along with certain documents, my lord. I got the document initially, but it was not authenticated. Thereafter, they are authenticated, and yesterday I received. Lordship kindly extend, my lord, only for a week that I intend.
You've taken extensions earlier also, Mr.
My lord.
Please be ready on the next occasion.
Fine.
Learned counsel for the respondents seeks further extension of time to submit the report in the form of affidavit as sought. Paragraph, let the matter appear under the same date, 13th.
Along with the document, my lord.
13 was,
That is already there.
lordship kindly fixed on 8 or 6.
8. Turn to 8. Next.
Lordship, in this matter, I am
for the petition.
I am appearing on behalf of the Union of India. Lordship, in this matter, I filed my report in the form of an affidavit and
May I file, my lord,
all-
my exception?
exception. I received the same on Friday, and there is one thing. I take some instruction, and it will take some time, Lordship. Kindly fix.
Lord, I am opposing this prayer because, my lord, this is one of the case, my lord, of the railway's high-handedness. While pending writ petition before your lordships, they sought for extension to file, my lord, the report and terminate my agreement. And, my lord, I have in, my lord, in the exception, my lord, I have not disclosed any factual aspect.
In
So,
this
my lord, there
matter,
is no
Lordship,
question of taking further
I have
instruction.
take only one.
The 2 extension was granted, my lord, to obtain, my lord, the report. And, my lord, yes, there are as per the 15th and 31st.
Only one day. Lordship, only
And, my
one
lord,
day I
it is that
take
on
my
the face of the termination letter, my lord, I have argued, my lord, on the first date, my lord, it doesn't stand even in view of the Supreme Court judgment, my lord. And I have not even disclosed any point, my lord, which is not, my lord, were not there in the writ petition. Not even a single
Lordship, in
factual
this
aspect.
exception is one point in the termination one letter I served my client and আমাদের exception
Exception has no annexation.
Yes, Lordship. In this exception, kindly come to page page 84. This letter was
page 84.
Okay.
My report,
Reports.
my report. Lordship, this letter was served by my client, but he said in the exception that they had not received
My
the
lord will
letter.
kindly see from the letter, there is any endorsement, not even, my lord, my argument is that even if he admits that letter is there, my lord, still, my lord, I have a case, my lord, under the circular they are relying on. My lord will kindly for once, my lord, see, my lord, the termination letter. And everything will be clear, my lord. The termination letter, which is appearing at, my lord, page 78, my lord. The two clauses they have relied upon, the two clauses is absolutely not applicable.
They are harping on discontinuation without notice.
And the notice is annexed. I have annexed the notice, my lord, which is at page 80 of the writ petition. And response to that, they say it was not given to parcel supervisor. May I just? It was not given to parcel supervisor, but the chief commercial manager. My lord, under the agreement, he is the railway administration defined. Why should I give, my lord? He is the person who has entered into the agreement. Why should I give a subordinate officer, my lord? My lord will see, my lord, page 78. But this, they say you were leased 24-ton space in LVPH number 1804, 18045. These are two clauses in the between. They have enclosed. 8.4, if the leaseholder after commencement of loading fails to operate the contract continuously for 10 days without giving any notice, his contract will be terminated and security deposit will be forfeited. My lord, kindly come to page 80. This is my letter for, my lord, suspension.
Yes, yes.
So, my lord, there is the 8.4 could not have been made applicable. And my lord will also see, my lord, they have even debarred me from participating. On the last occasion, my lord, I have relied upon a judgment of a Supreme Court, my lord, that clearly says, my lord, if there is a debarment, I have to have given a notice, my lord. That is the principle of natural justice. My lord, today, my lord, they are in a benefiting position. They have given a contract to a third party. They're enjoying my money upon forfeiting. My lord, this termination letter cannot stand, my lord. I am entitled to the refund of my security deposit which they have forfeited. And my lord, what they are saying in the report that by that letter, my lord, they have asked, my lord, to resume the operation. That 9th January. There is no document to show that it was at all received. Even if I say, my lord, that was issued, if your lordship see, my lord, what my learned friend is showing. They say, my lord, on 9th of January, they say, my lord, I should start resume. And 12th of January, my lord, they terminate. Where is when the time given? When it was served?
Lordship, that's why I am asking.
9th of January, a letter, my lord.
For that instruction that he has served the notice when they
The
served
verbal
that
instruction will not suffice, madam. Please come back with the documents.
Lordship.
Please come back with the documents to show that you
Yes,
have
Lordship.
served.
If there is some document, I will.
Necessary, please
Otherwise,
file a
I will concluded that hearing on that.
Please file a supplementary affidavit if necessary.
If
annexing
necessary,
the relevant documents.
if the document is with me, then I will
If there is no document, you cannot, obviously.
But my lord, in that case, my lord, because they are because the problem is, my lord, they have given it to third party that they have admitted. They have given it to third party, my lord. They are now enjoying on my money. My lord, then if they are doing it, my lord, kindly direct them to put the money before this honorable court.
But if handing over to the third party is not legal, then that has to be called off.
Lord, that is the position today I am suffering, my lord.
And Lordship, there are
And what my lord will see, I have filed a writ petition asking for 5 minutes, 10 minutes. My lord will see all the order sheets every day come before your lordship and seeks for an extension. In between terminated, not even informed. After that, the matter was taken up, not even informed this court, my lord. And my lord, they proceeded with the termination.
Lordship, there is a provision for appeal.
Why should I go before an appeal? This is the case, my lord. I am covered and natural justice is covered under her.
There is a provision for appeal. Yesterday, one matter he is doing there.
My lord, in that case, my lord, I am covered by a judgment of Supreme Court. I should not go.
If no notice was served, it's violation of natural justice. The writ court will deal with it.
That's why I am.
Please come back with instructions. Please come back with instructions.
My lord, kindly give them mandatory direction because this is pending for quite.
Learned counsel for the respondents seeks to take further instructions in this matter. Exception to the report. Exception submitted by the petitioner to the report in the form of affidavit submitted by the respondents is taken on record. Learned counsel for the respondents seeks to take further instructions in this matter. Paragraph, let the matter appear under the same heading on 6th March.
Just wanted that I saw.
Lordship, I am for the petitioner led by Mr. Omar Farooq Ghazi. Lordship, on last occasion, we are directed to file an exception on the report which has been given by the respondent authority, Lordship, but the exception report has not been filed yet, Lordship. I am seeking for 1 week accommodation, Lordship. Kindly give me 1 week time.
Any day, Lordship.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 8th to
Lordship can fix any day. I am not interested.
no, you are not available till
My lord, 11 to 22.
22.
That is why my lord, I on the mobile mode not more. This matter can be
Considered.
any day, Lordship.
18th March.
Fine. If no,
This is this illegal plying of auto rickshaws.
that is already my lord submitted report. There are series of vehicle has been seized. Already complied with. Already complied.
The petitioner wanted to take instructions. Let him come back.
Already take steps and regularly checking was there.
Next. Yes, Mr. Mukherjee.
What is this matter, your lordship? Kindly.
Are you filing an exception today?
But
exception the only
exception is ready. My client's she is very much ill. She is the lady one. He informed that she will come tomorrow. Let it be taken up any day the next week. Only a few lines of I have prepared this. Today it's going to be upon my lord. I will hand over. Even advance copy. Tomorrow I will hand.
I'll give you a short
Any day, nothing is there. This is an application against the order passed by the Appellate Forum. That is the tax matter.
Tax matter.
Yes. So they have already filed the report. The money is lying with that part. Mr. SUVRA also assured the last occasions that will not be forfeited or the
dependency cannot.
that also. The bank guarantee as well as the
standing instructions.
that is there. I am not on that.
Pilot is there.
So that if it is taken up, then this may be this all will be solved because the
First March.
Month.
Or first instead of first month, let it be.
Let it be.
Let it be a
second month.
Second month, Rovibar, Shonibar,
Second, third, fourth.
Fourth. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 4th March.
March.
Oh, 4th March monthly list.
5th March.
March. Thank you, dear. Other case also there.
This is a tax matter, my lord. Petitioner could not fly the vehicle during the COVID period. And thereafter the vehicle was off-road.
Who is appearing for the respondents?
But only one thing, my lord, your lordship kindly have a look at. Without counter signature, the authority cannot realize tax. That is the section 7 of the Tax Act. But here, my lord, one. One letter has been issued by the RTO, my lord.
At page?
Page. Yes, that I made a representation. Representation, my lord, page 38. and letter of the ST Jharkhand on page 57.
This is a request for counter signature,
Yes,
not done.
counter signature,
Counter signature is not done.
not done. Only one point, my lord. Letter dated 19th April 2023.
Issued by
Issued by the STA West Bengal.
at page.
Let them consider my representation, my lord. Because it is admitted position in the representation, it has been contended that so long the counter signature subsists, the authority is empowered to realize the tax. Beyond counter signature, they cannot realize the tax.
That should be considered. Yes. The innocuous prayer of the petitioner is for consideration of the representation submitted by him before
My lord, respondent number 3, Additional Secretary, Transport Department. But your lordship asked a similar order, my lord, your lordship, I'll have a look at that order.
before the not necessary before the third respondent on 7th August 2023. Paragraph, in view of the submission made on behalf of the parties, comma, the writ petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 4 weeks. Within 4 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of which? Next.
That I picked it. My lord, as per my lord, last direction on last occasion, report has been served upon me on yesterday.
Yes. This is your report.
Yesterday evening, I have got the report, my lord. But
An exception.
I want to file one exception, subject to my lord kind consideration. If my lord allows me, I can place only 2 paragraphs of the report. Para 8 and para 10. Here my learned senior friend's client has taken a very neutral stand, which is specifically stated as para 10. But my humble submission before your lordship, that still now the buses are running in that route. And apart from that, nowadays, my lord, no physical inquiry is required regarding the movement of any commercial vehicles, because my lord knows very well, better than me, that each and every commercial vehicles device has been.
A tracker is there.
Yes, tracker is there. So no physical inquiry is required. If they want to verify that my allegation is true or false, they can very much able to see in their room itself. And my learned senior friend's client.
What is the prayer in the repetition?
Prayer, my lord. The bus route sanctioned for 125 kilometers
from Sonarpur to Bagnan, but they cut short the route that 125 kilometers to only 25 kilometers. And they are flying their bus from Bhojerhat to Bagbajar, which is not at all the sanctioned route. My lord, it would be evident from the picture itself, which I have annexed in my writ petition, page 24, specifically on 25. It is not at all the route. Ghatakpukur to Newtown Sector 5 via Sambajar, Bhojerhat, Bagbajar. Bagbajar is not permitted route, my lord. My lord, if your lordship,
So your allegation is against the private respondent for curtailment of route.
this is the only one instance, and another bus of this route is flying. I have only made party only one bus owner, but other buses are flying by violating the rule. My
one thing, this player lordship file is
দাদা এক মিনিট
page 16
এক মিনিট আচ্ছা
বলে দিচ্ছি।
ঠিক আছে
Player E, my lord, he asking for consideration of the representation dated 5/12/23. Lordship may direct the authority to consider the representation and at the time of hearing asking the private respondent to present there. That will solve.
and all other similar situated persons, my lord,
All stakeholders.
Concerned.
all stakeholders of that
Where is your representation?
representation, my lord. It starts from, it is a demand justice, my lord. It starts from page 26. 26, my lord.
এটা তো advocate letter.
Now,
Why don't you file a comprehensive representation before the authority?
my lord, my
Yes.
lord, my lord.
Stating and all
My
the
lord.
facts.
That is better.
That will be better, my lord.
You will be called by the authority. You'll have an opportunity of hearing.
And other similar situated bus owners, my lord.
I'll just record
Mine.
it as all concerned.
Mine.
Yes, Mr. Debra.
All the interested person.
Report in the form of affidavit submitted on behalf of the state respondents is taken on record.
আমি তো আপনারই ছাত্র।
The primary grievance of the petitioner is that buses, including that of the private respondent, are flying from Sonarpur to Bagnan. That is your allegation.
Yeah, my
From Sonarpur
to Bagnan.
That is a
to Bagnan.
That is permit route. They allegation they are not following the permit.
In violation of the permit granted in their favor. Stop. The petitioner seeks to submit a comprehensive representation before the concerned authority in this regard and prays for a direction upon the authority to consider the representation at the earliest. Paragraph, learned counsel for the state respondents submits that who should consider? The secretary?
That is, my lord, that is better, my lord.
Or the board?
Board.
Board. State Transport Authority, that is the main.
Two.
Respondent number two.
The second respondent be
Number of
directed.
buses flying operating from granting permit can be
Yes.
operated by this.
The second respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of with liberty to the petitioner to submit a comprehensive representation ventilating his grievance before the second respondent within 2 weeks.
1 week, my lord.
1 week.
1 week.
Within 1 week from date. Stop. The second respondent is directed to consider and dispose of the representation within 4 weeks.
Within 6 weeks, because there are
Board.
number of interested.
Within 6 weeks from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondent, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of, exactly. Next.
Yes, it please your lordships. May it please your lordship, I am appearing for state in this matter. I am led by Mr. Owen Banerjee.
You are the petitioner, yes.
In this matter, madam, one application additional party was filed It's my objection.
Who filed the application for addition of party? I do not find anyone
Robindranath.
to be added as a party. You are appearing for the state, you said.
Well, in this matter, the petition before matter having a state gas permit made a prayer for diversion of the route for some portion and for a curtailment. That represents page 17 Mala and step P3. So I am praying, my lord, your lordship will direct the second respondent to consider the representation.
Diversion of route.
Diversion and curtailment. Some portion diversion. Diversion of the route.
The can will be dismissed for default.
Right.
And 1 of 2024. Since none appears for the applicants on call, comma, the application being can 1 of 2024 is dismissed for default. There shall however be orders as to costs. WPA order. Heard learned counsels for the parties. You are filing an affidavit in opposition.
No, my lord. I find
To the can.
They can, my lord.
Oh,
can.
ওটা ওখানে record করে নিও। Affidavit in opposition filed can record করে নিও। Affidavit in opposition filed by the petitioner is taken on record. তারপরে since no one appears. WPA order করে heard learned counsels for the parties. Paragraph, the petitioner is a permanent stage carriage permit holder in the route Goramba, Garamba, Garamba, Goramba to Novabhat, and submitted an application before the concerned authority on 5th June 2023 for diversion / curtailment of the said route. Stop, the application is yet to be considered. সবগুলো application করবেন কিন্তু, হ্যাঁ? প্রত্যেকটা। The petitioner seeks a direction upon the concerned authority to consider the application at the earliest. Paragraph, learned counsel for the respondents submits that who should consider?
My lord, two.
The second respondent be directed to consider the application in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the second respondent to consider and dispose of the application filed by the petitioner dated such and such within 6 weeks, board, 6 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof, disposed of which after.
Much obliged.
Then also application by additional party. I find my
opposition.
Well, in this matter, my lord.
Who is appearing for the applicant?
Alex Felix, my lord.
Who was appearing on the earlier date?
On the other day, my lord, Mr. Felix appeared.
Yes.
On the other day, Mr. Alan Felix appeared.
Oh.
In this matter, my lord, petitioner applied for grant of permanent state gas permit that was decided by the respondent number 2 and issued offer letter. Well, pursuant to the offer letter, purchased a new vehicle, BS6 compliant vehicle. I have submitted all papers. I made a representation for grant of permit. My lord, permit has been withheld for some reason, I don't know, my lord, but I have complied with all the terms.
Permit has not been issued.
Not issued, my lord. Supreme Court judgment is there, my lord. My land affair knows my comptroller is a case Jagannathan.
Mr. Debra?
Some timetable dispute is concerned.
No, nothing.
Of course, timetable.
Unless you grant a timetable, how can you put an objection?
That is.
First of all, no, I have made a represent page 19.
A provisional timetable has to be
Yes,
granted
that's
first,
the law, has been settled by this court.
then objection invited.
Lordship, you direct the
Yes.
secretary to take steps on the basis of the offer letter and also submission of their
Well, I
respective.
have complied with, I have submitted paper.
If you
document.
comply, if
Yes,
you
yes,
comply,
yes, that's the deal.
if you comply, there is no allegation.
I've got my vehicle registered, registration number is there, my that I have produced vehicles. Everything I have complied with. Page 19, madam.
Let this be considered. I'll record your submission. and let this-
If possible, let them grant because.
Yes, yes.
আমি বলে দেবো
হ্যাঁ সেটি বলছি।
আমি বলে দেবো
56,000 কিস্তি।
Can I order করুন? Say it first, আগে যা বললাম, আগে তো affidavit in opposition আছে। তারপর since none appears, dismiss for default করুন can টা। Can is dismissed for default.
Yes,
Right.
WPA তে করুন। The petitioner applied for issuance of permanent stage carriage permit and offer letter was issued in his favor. On 30th October.
Yes, ma'am.
On 30th October 2023, pursuant to the resolution taken by the RTA Purbo Bardhaman on 16th September 2023. Stop. The petitioner purchased a new stage carriage of BS6 compliant, BS6 compliant stage carriage. Compliant stage carriage. Aage stage carriage deben na. And has complied with all requisite formalities, despite which permit has not been issued in his favor. Stop. The petitioner submitted representation before the concerned authority on 1st December 2023, requesting issuance of permit, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to
This one was 3.
consider the representation and issue permit in his favor at the earliest. Paragraph. Learned counsel for the respondents submits that the respondent number 3. Third respondent be directed to consider the representation submitted by the petitioner and take necessary steps in terms of the offer letter issued. Paragraph. In view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioner dated 1st December 2023 and take necessary steps in terms of the offer letter issued in his favor on 30th October 2023. Stop. The entire exercise is expected to be completed within 1 month.
My lord, kindly, for that time, my lord. 56,000 per month installment. I have been paying.
Less than 1 month, how can
Well,
they
get them,
dispose
Malad.
of? I don't think.
Oh, yes.
Let it be 4
If
weeks.
preferably, my lord, your lordship can use that word preferably.
Within 1 month.
Within 1 month from the date of communication of this order.
তো bargain তো তুই
না ঠিক আছে তুই বলে দিলে তো
তুই তো bargain করতে না bargain করছো কেন? আমি বললাম bargain
Dispose of which? ওই ওটার আগে the decision taken by the authority shall be communicated to the petitioner within a week thereof. তারপর the entire exercise. হ্যাঁ ওটা আগে রাখো। Next.
ঠিক আছিস? আমি তো শুনবো ঠিক আছে
Well, in this matter, I have made an application for addition of party, can number 1.
And one, copy পাইনি।
That's how.
Can one does.
কোনটাকে ভুল করে দিয়ে দিয়েছে। এই কপিটা একটু দিয়ে দিবেন তো। এই যে কপিটা নিন, কপিটা নিন। সেদিন দাঁড়িয়ে।
স্যার কি আপনি
But this application, my lord, I am holding a permanent stage carriage permit on the road.
To the can. You've received a copy?
Yes, I've served to all these parties.
Can 1. The petitioner seeks to use an affidavit in opposition to the application. Paragraph affidavit in opposition be filed within 2 weeks. 2 weeks from date.
Short time, 1 week.
From affidavit in
So I am
reply,
affected.
comma, if any comma be filed within a week thereafter. Paragraph, let the matter appear under the same heading.
Or may I submit one thing? Let it
Yes.
be.
Because my lord,
It can be
objection,
disposed of.
on the basis of objection, hearing was called. But when the hearing was called, all the parties appeared.
Spending.
But all the parties appeared.
That has to be heard.
But the council appearing
Opposition against the can.
Immediate opposition against
The petitioner was to.
on the basis of the objection.
objection this is.
No, on the basis. Well, I made a representation on the disputes of timetable. But all the parties were called for hearing by the STA.
The church is
At
considered.
the time of hearing, and the council appearing on behalf of the my lord petitioner, made as the matter sub judice, read petition file, so matter meeting was adjourned, postponed. I have an hearing notice. Kindly see the last meeting.
Lordship, kindly see his prayer.
Last meeting, page number 30. Page number 30. Page number 29, objection.
Khan, দাঁড়াও না, একটু দাঁড়াও, Lordship, kindly see his prayer. That will better. Page 10, paragraph A. Prayer A. Basic facts.
I will not allow to add the respondent to.
No. At the time of consideration, they have to be heard.
Not in the.
He is affected. He has to have.
And allowing them to add.
That is another aspect.
Joining.
May I submit one thing, my lord? I can't remember again.
I have to dispose of. Where is the disposal? That the applicant has already filed the.
All concern may be heard.
Where he has been stated, what is the number? Nothing has been given.
Well, I'm giving the number. Read petition number again. Then.
But then I have.
No, this is not the subject matter.
I don't.
Well, I made the objection. Kindly see the page number 30.
My lord, I must have to give an opportunity to controvert this. Whether he is at all unnecessary.
I'm giving the number. Well, kindly see the page number 30. On the basis of objection, hearing was called on.
1st April.
Smile.
1st April.
Next. Can I order? Can I order? 1st April, can I order?
But in this matter, my junior moved this matter in Raja office. Point is, my lord. But
Mr. Debra?
yes.
This matter?
Point
Yes.
is, my lord, petitioner applied for a route. For a non-notified A to Z. Petitioner has been allowed C to Z. A to C, a sumoto cartel, that they cannot do. RTA Purulia. My lord, under section 71, choice of the route completely depends upon the petitioner. And liberalized policy as envisaged in section 80, permit can be made at any point of time. And more so, but in the self-same meeting, the self-same authority has granted permit in respect of a longer route, which is longer than my route. Purulia. My lord, your lordship, impugned Otis Gupta.
Mr. Debra wanted to take instructions.
I have to take it.
Well, this is a simple matter, my lord. Your lordship can dispose of it. And I think Mr. Debra also agree. My lord, page 34 is the improved resolution. And petitioners, my lord, serial 13 resolution, my lord, as the route is very long.
Yes, that is recorded in the earlier order.
Yes. And my lord, on the other hand, but I have annexed, my lord, page 37. There is the Purulia, this route, Borabajar to Bandwan.
It's a longer route, yes.
Longer route. And it has been allowed. So, my lord, I am paying, my lord, this resolution be set aside. So far, the petitioner's application is concerned, and my lord, the grant the part, because they granted permit.
Lordship, kindly take it up next week.
Next week. On prayer of the
Next
respondents,
witness, Lordship, next witness.
on prayer of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 28th. Next Wednesday is 28th.
28. 28.
Next Wednesday is 28th.
Yes, yes, I'll be.
How much? 28th.
28, Lordship.
Next.
My lord, in this matter, I am appearing, my lord, for the petitioner, my lord.
Yes.
My lord, the prayer which I will seek for, I believe my learned friend will also not oppose.
Yes.
My lord, the petitioner herein is, my lord, the association of the cab taxi, they who are running, my lord, of that associates, my lord, and the owners and drivers are the members of that association. My lord, they have been running their Tata Magic taxi plying from Bali Hall to Durganagar since about last 8 to 10 years. My lord, in the meantime, my lord, a new route has been introduced from Dankuni to Doltola. My lord, the petitioners had made a representation ventilating their grievance. Your lordship will find it at page 29, annexure P4. That has not been redressed, my lord. My simple prayer is, let a direction be given.
My specific instruction, there is no route for this.
There is no route.
No
Lordship,
new,
kindly see, my lord.
no new route.
Please, no need.
Oh, কালো তো?
এটা দেখো না।
তাহলে গল্প শেষ হয়ে গেল।
Creation of a new magic route transformed to Doltola, and this was new permit which was no base. No such route was created from this end, and no permit was also issued in the same route.
ঠিক আছে।
This is the third paragraph, my lord. Paragraph third.
Since we made representation, it was unreplied. If the reply would be given, I would not have to file this writ petition.
Let the writ petition be. So no further cause of action.
Record and dispose of the matter, because Mr. Mukhopadhyay is my good friend.
I'll record that also, Mr. Dev.
Yes, that may be recorded, my lord.
Since learned counsels are good friends, let
Yes,
me
yes.
dispose.
It is my instruction.
It is well that we are having our long-standing tradition of the bar. We are maintaining our friendship.
Or learned counsels for the parties. The primary grievance of the writ petitioners is that though they have been providing services to the passengers in the route Bali Halt to Eco Space, they have recently learnt that one new route has been introduced by the third respondent from Domdom Park to Dankuni via Nager Bajar, which is overlapping the existing route of the petitioners. Stop. The petitioners submitted a representation in this regard before the concerned authority on 9th December 2023 and
9th November, my lord, it should be, because receiving your lordship at the bottom will find on 10th November.
1 and 2.
Yes, 1 and 2.
All right,
Perfect.
9th November 2023, and have prayed for a direction upon the authority to consider the representation at the earliest. Paragraph. Placing reliance upon a letter issued by the Secretary, RTA, North 24 Parganas, Barashat, issued on 18th January 2024, Learned Counsel for the respondents submits that no route has been created from Dankuni to Doltola, and the apprehension of the petitioners is without any basis. Paragraph, in view of the above, this court, nothing further remains to be adjudicated in the writ petition, and the same is accordingly disposed of.
Instruction kept on record, madam.
Instructions submitted on behalf of the.
Deeply
This is
obliged
not
to
an
you.
instruction. This is just a letter.
It's only written. Yes.
But a copy of
Copy of the letter.
of the letter issued by the Secretary, RTA, North 24 Parganas, Varashat, on 18th January 2024, submitted on behalf of the state respondents, is taken on record. Disposed of or urgent certified statement. Next. Yes, 813.
Oh, এটা 213 বিভিন্ন সব কোথায় গেল সামন্ত তো বাইরে নেই আমার জুনিয়র রাখবে আমার জুনিয়র রাখবে না That's my idea. But can they make it not to the one? I have not told them it.
Not today.
Fine.
Next.
This matter, I am appearing on behalf of the petitioner.
On last occasion, my lord was pleased to direct me to file a report. My lord,
yes,
I gathered from the entire papers and documents, and I had a talk with it is NOC between Birbhum and Bardwan. My lord, now Birbhum says that the route covering the major portion lies with the Birbhum authority. So he has to apply before the Birbhum authority for granting permit. But difficulty, my lord, he has, then my lord, I had a talk with the RTA for Bardwan also. He said that something is wrong was happened. And then, my lord, then he asked for the RTA Bardwan asked the petitioner to file an application for further extension of the route within the Bardwan area so that they can, the Birbhum can issue the no objection certificate. That is the, but pursuant to that, my lord, he has filed an application before the RTA Bardwan for extension of the route up to certain portion in the Bardwan area so that Birbhum can issue the NOC. This is the actual position, my lord. Lordship.
So why don't you come back with a complaint? Because let the application. Is the writ petition required to be kept pending?
Yes, that is pending. That is pending. But I am placing the matter. Or I applied for grant of Malord's discarriage permit on the route Malord Bardwan Novabhat to SUVRA.
Yes.
All of that matter was placed before the RT board meeting. In the meeting, it was held that the major question fall after making inquiry from the MPI. The major question fall within the jurisdiction of Bardwan. And so what is really not decided to issue offer letter. Before grant of offer letter, Secretary RT Bardwan requested the Malord Secretary RT Birbhum to issue no objection certificate so that offer letter can be issued. On the basis of that.
Yes, that was issued and cancelled.
Offer letter and permit was granted. Offer letter was, then we have after purchasing the vehicle from the bank. When the Malord after grant of permit, we have to submit, we deposited one counter signature fees. The other counterpart. Thereafter they give the reply on the basis of the complaint for the other association. the major portion falls into the case of Bingo, that inform the active part, sorry, we cannot countersign because only 5 kilometer portions falls not within the.
Now you have filed an application for extended portion
Yes,
within
yes.
Bardhaman, yes.
Before that. My lord, we have already filed an application for extension within the Bardhaman district. My lord, that after if the route is extended, but major portion of the route will be fall
in Bardhaman, yes.
Bardhaman, because total distance route will be 128 kilometers. After extension, route will be 68 kilometers within the territory district.
There is no further cause of action in the writ petition.
So that it can be decided in this writ petition because I that is kept on record. It may be dispose of that.
Then I'll record your submission and dispose it of. There is nothing further to be.
Nothing further, nothing
Yes,
further. Because a record submission and lodging.
But it may be kept on record that we have made an extension of the within the territory that may be kept on record and can be disposed. And also directed the authority to extend the route and to obtain the NOC from the counter from the other counter so that government already granted. A timetable was issued time to time, but I stopped flying the vehicle.
That direction cannot be given in the
Only
petition.
first considered for extension, then question of.
And all the part was granted.
Third learned counsels for the parties. The no objection certificate granted by the RTA Birbhum was subsequently cancelled on the ground that major portion of the route applied for by the petitioner fell within the district of Birbhum and the petitioner ought to have applied for grant of permit before the RTA Birbhum. Stop. Paragraph. It is submitted on behalf of the petitioner that the petitioner has applied before the secretary, RTA, Purbo Bardhaman on 11th December 2023 for extension of the route.
Boro Moria, my instruction page number 1, after 4 lines, from Boro Moria to SUVRA.
From Boro Muria, BOROMURIA. Route from Boro Muria, BOROMURIA to Shuri. As a result of which, major part of the route shall remain in the district of Purva Bardhaman. The application is yet to be considered. Stop. Paragraph. Since the ground on which the no objection certificate was cancelled by the RTA Birbhum has been met by the petitioner, nothing further remains to be adjudicated in the writ petition, and the same is accordingly disposed of. There shall have been
Consider that.
That is not your prayer in the writ petition. That's a subsequent event. You have already filed an application. At paragraph colon, it is expected. I'll put it. It is expected that the application filed by the petitioner for extension of route within the district of Purva Bardhaman shall be considered by the authority at the earliest.
What time?
Beyond the writ petition. Disposed of which action? Disposed of looking for a government. Urgent set of website.
Madam, for the state.
Yes.
Your lordship's order at page 23. Right.
Last order, February 20. In case Mr. Devra
Yes, a palpably wrong order. The state, you wanted to take instructions in this matter.
Lord, I have been engaged in this matter. I do not know.
Mr. Devra has been appearing all through.
But it is in my name, my lord. My name and my junior, Mr. Shukla. If your lordships allow me, I'll appear, otherwise.
I am no one to either allow you or disallow you.
Lord, miss করেছিলে, miss করেছিলে। Miss করেছিলে।
Instruction was sought.
Lord, may I argue the case? May I argue the case?
Yes.
Your lordship, kindly see your lordship's order at page 23. And in terms of your lordship's order, the last order has been passed, that is at page 36.
Please see the order passed in this writ petition on 6th February.
Subject to my lord's corrections, my lord saying that we will argue on this.
No. What I have seen, not prima facie, what I have seen, in terms of your lordship, in terms of your lordship's order, the order has been passed by the chairman ST and secretary ST, that is at page 36. Whether the section 80 and proviso 3, whether it is applicable or not. May I read it out? Read it out, not. Your lordship, kindly see that. Page 36. Subject reconsideration. Your lordship's order. Let me go through your lordship's order first. Your lordship directed to revisit. That is at page 28.
Yes.
Page 28, not the third paragraph. In view of the above, this court is inclined to hold that the concerned authority be directed to revisit the issue upon placing the same before the STA board and granting an opportunity of hearing. For opportunity of hearing, notice was served. He has made an application, Lord, your lordship, kindly see at page 32. He said that because of the flood, he did not. Your lordship, kindly come to page 32.
I think it will be more useful if you can go through the order passed by this court on 6th February. 6th February 2024. The last order in this writ petition.
হ্যাঁ আছে তোমার কাছে আছে হ্যাঁ
The order impute has been dealt with in this order actually. That's why it will be held.
Then let me come back with the instruction. Let me come back with this.
Pure questions of noise need not be required to take it because two things. One is this one that it is very clear. I have never told anywhere that this notice has been not received by me for the class. That has been gone.
Wrong premise.
That part gone.
আরে দাঁড়া শুনতে পাচ্ছি না তো বলছি
The order has been passed on an absolutely misconceived notion.
My lord, may I submit one thing?
তুমি ইনস্ট্রাকশন পেয়েছো
আমি বলে দিচ্ছি
বলো বলো
may I submit one thing? He has said that he has not given a survey notice. Lordship, kindly see.
বলে তুমি দাঁড়াও নি লাস্টের দিনকে দেখি কি দিয়েছে ইনস্ট্রাকশনে কি বলেছে
Lordship, kindly see, my lord.
Yes, where is the service?
He has delivered. He has delivered on
17-10 লিখেছে ডেলিভার্ড এখানে দেখো
delivered
এখানে দেখো এখানে
16/12/2023.
বলে দিয়ে দাও না
Last annexure, last page of the track record. Abdigram ki Dhiragram. Dhigragram. Got it, my lord? Dhigragram.
Yes.
I received.
Yes, item delivered. Addressee.
5th October এটা কবে ডেলিভার হয়েছে
16th December 2023.
এখানে ও বলছে যে decision taken by the authority in the meeting on held 9th October a sealed of in the read petition. It is recorded that the petitioner received the notice hearing on 5th October.
Then my lord, 5th October, lordship kindly see, prior to that,
The court, page 30.
immediately after instruction, my lord, immediately after written instruction, immediately, my lord.
Eta poro, page 32.
Mr. Mukherjee, have you received a copy of this instruction?
Lordship kindly see, this is
That as it may, your
for
lordship.
5th October, lordship.
I'm not,
Hey, one-
as it may. Only two things I have annexed here is that the one is the, my lord, your lordship, page 31 of my writ petition.
But the same consignment number in the
Can you
instructions.
see next page 32? It was the flood that has been given. It was there was a flood. Your page
That is a page 32 in the month of October.
5th
Flood.
October 2023.
Yes,
Lordship
that
kindly
yes,
see the
I
exact record.
kindly see. Plavito, your lordship kindly see.
And eta porche, page 32.
Who wrote a letter? I do not know.
To whom it is addressed.
Who it is at the, who wrote a letter?
Page 32, your lordship
The
kindly
lead
see.
officer of the Maladi Postal Department. There.
Postal Department track record is there. Item delivered address.
Your lordship kindly see that I'm not even I'm not on that.
5th October
Even I'm
2023.
not pressing that part.
The track report is there.
No, I'm not
5th
pressing. Even
October
that documents is there. I'm not pressing. I am on this part, the decision taken. Only this part and decision taken. Your lordship kindly see what is the decision?
Page 36.
Yeah, page 36.
Yes, hearing was
Party
given.
for curtailment of portion, so and so to so and so.
The order, the resolution says that alteration of termini is not allowed.
Yes, that's
Petitioner has not prayed for alteration of termini at all.
Cartleman.
Cartleman,
Cartleman cannot allow.
section 8,
Cartleman cannot allow, my lord. Cartleman means he has to apply for a fresh.
fresh.
Because his route is from Howrah, he cannot, because due to restriction imposed by the division bench of our High Court, FMS 604 of 2004. Well, Mr. Mukherjee also knows, the new permit cannot be granted. Also, kindly see my instruction, my lord.
Page section 80.
My instruction, first page, second page, also kindly see. Last portion, the corresponding bid number.
The petitioner has prayed for curtailment in between, not the termini. He has not prayed for a change of termini. The resolution says termini cannot be changed under section 80, subsection 3.
Yes.
Section 83, provides the fee.
Yes.
Our
But
section
petitioner
80
has, that is not the prayer of the petitioner at all.
And my lord, section 80 subsection 3.
If the variation is there, then my lord, question of variation can be passed, can be. That
Eta
is
poro,
after
eta poro,
satisfaction
eta
of the
poro.
authority.
These two
That is
provisos
after
which they have-
satisfaction of the authority.
No,
They
no.
have taken two provisos, what my lord, section 80, an application for vary the conditions of any permit other than a temporary permit by inclusion of a new route or routes of new area or by altering the or area covered by it or in case of such permit by increasing the number of above specified or by variation.
Extension.
Variation, then my lord, the comma extension or curtailment.
Yes,
My lord,
yes.
of the route. Now, my lord,
Yes.
the lordship can see
Curtailment.
this proviso relates to the second proviso. Further that in case of variation, the termini shall not be altered and the distance covered by variation shall not exceed 20 kilometers. Now, my lord, second, in case of extension, now, my lord, in two cases, where the variation, the termini shall not be altered and in extension,
দেখো
the
চোখে
extension
স্ক্রিনটা না থাকলেও পাবে না
are 24 kilometers. Now, my lord, in respect of curtailment,
24
there is no
kilometers.
such provisions provided in the act itself under
24 এটা এখানে লেখা
80 subsection 3 and this proviso, which my lord mandates that the in respect of curtailment, termini shall not be. That in respect of variation, and when the variation subject to my lord's correction, variation is the
Curtailment, variation includes curtailment.
Curtailment, it's comma.
Where?
It's comma.
Variation, when you curtail a route, you're varying a route.
You lordship, where? But the provisions is not, your lordship kindly see the act. I am on the statute, your lordship kindly see. In that event, your lordship kindly see, there are
Variation, extension or curtailment.
Yes.
variation, then extension or cutting.
Page 37, it is explicitly stated. 37 ta poro, page 37.
There are three contingencies. Where, but this is three contingencies. It is
Correct. Yes,
or
yes.
here exam. Now the questions arises whether the variation, then comma,
Then extension,
then extension.
then or any.
So there are three components.
No. Component, malad, comma, malad, you logically say
Comma means they are separate.
separate.
No termini point.
Termini point cannot be altered
be
in
changed, or
case
cannot
of
be-
variation, not in case of curtailment. The petitioner has asked for curtailment.
Curtailment cannot be even due to loss.
Where is the provision?
Section 80, is 80, section 83.
Where does 80 say that curtailment?
Malad, I'm reading it out.
Yes.
I'm porbo naki.
Petitioner has just read it out.
Malad, you logically provide, so you provided that it shall not be necessary so that 3 second paragraph, provided that it shall not be necessary so to treat an application made by the holder of stage carriage permit who provides the only services on any route to increase the frequency of services so provided without any increase in the number of vehicles. May I just read it out?
Yes,
Then
my lord.
close again.
Yes.
Provided that further, in case of variation, the termini shall not be altered.
Variation, not
Variation.
curtailment.
Then you'll also kindly come to my instruction copy diye to mandate ke. Lord, you'll also kindly come to the my instruction.
Only
Second,
in case of variation, termini cannot be altered. But the petitioner has not prepared for variation.
Then my lord, logically see my instruction. Sorry, my lord, interpret.
no.
Second page, any such variation or extension within such limits shall be made only after the transport authority is satisfied that such variation will serve the convenience of the public.
Where is it
Right.
stated? You said
And
it says that the MV Act states that. Which provision?
But
Which
that
section?
that is in respect of variation and malad extension. The authority must have to consider whether this
So this
extension
one,
and
3 things.
variation will.
Variation, extension, curtailment. You have dealt with variation and extension. You have not dealt with curtailment. Petitioner has sought curtailment.
curtailment cannot be. Lordship kindly see the alert I am coming. Again, I am coming. Then, my lord. First, 80 subsection 3. An application to vary the condition of any permit other than a temporary permit by the inclusion of a new route or routes or a new area, or by altering the route or routes or area covered by it, or in case of stage carriage permit by increasing the number of feet above specified maximum, or by the variation, extension or curtailment of the route or routes or the area specified in the permit shall be treated as the application for grant of new permit.
Yes, so
Grant of new permit. So grant of new permit, in case of grant of new permit, we cannot, because due to restraint order, due to pass by this honorable court in the 2004. Everybody knows, my lord, Sujata Ganguly's case.
that is FMS 604.
FMS 60 lordship and my instruction, these are recorded.
And এটা পড়ো, last paragraph টা পড়ো. Consequently, no case of curtailment. এটা
This
পড়ো.
is document second page, lordship and see. There is a notification upheld by this honorable court.
No new point permits.
where are you reading?
The second page, man.
In this case, application for new permit cannot be allowed as per order. The famous HON'BLE High Court notification dated that no new permit shall be issued in the Central Business District, Esplanade, Bandstand in Kolkata, Howrah Station and approach area of Howrah Beach, till further order. Therefore, no new permit shall be given to any applicant, but the termini point end in Howrah as per above mentioned order and notification.
তারপরেরটা পড়ো, consequently.
No case of curtailment allowed as per clause 1, I and II of subclause 3 of section 80 compromising the movement of people in general. The decision was conveyed to the petitioner. This is my respectful submission. They cannot. The curtailment.
Let us hear the.
Normally, you also can see the route and my portion of cattle. Everything outside this particular notice. This has been given in respect of an order passed by a division bench, that in respect of the routes which terminate within the central business district, and central business district, my route is altogether a different route. It is within the jurisdiction of the regional transport authority of 2 districts or 3 districts, which calls
Now we are on the decision of the STA chair.
where the Howrah, where the
Your route is Mansuka to Howrah.
so this is curtailment. That means I have for myself changed the portion of the route. That is from the end part. So it is already there.
No.
Mr. Mukherjee, let us make it clear. At present, you are running from Mansuka to Howrah.
Yes, it
Present
is good. Right.
And you want a curtailment from?
Mansuka to Boroda Chowkan, your lordship will find at 1236 it is subject. Reconsideration of application for curtailment of route Mansuka to Howrah. The curtailment portion is Mansuka to Boroda Chowkan.
So you still have Howrah as your termini.
That is there. That was there, that is there.
Yes, but if your curtailment application is considered as a new application, then you cannot ask for the Howrah terminus.
Then I shall petition all in respect of curtailment.
What is flying. That has not been touched. But you cannot apply for, you cannot.
Subject to my lord's correction, this curtailment cannot be set for this application which I have made, that for curtailment.
That will be treated as an application for a new permit.
Yes.
In all respects, all the applications are treated to be grant of a new permit. Okay. So far as subsection 3 is concerned. Now let you also kind of see.
At the moment you ask for a new permit, you cannot ask for the Howrah terminus.
I am not asking for a new permit. This is
Curtailment will be treated as a new permit. Application.
I shall judgment therein, where my lord, this cannot be said to be a grant of a new permit.
The statute says so, sir.
Statute.
An application for curtailment will be treated as an application for new permit.
New permit.
Section 83 is clear.
What area? Service is an application for grant of a new permit. That part.
So the moment it becomes a new permit application, you cannot touch upon Howrah.
So what else? Then the curtailment will not be allowed on the ground of not on that ground, only on the ground of that the central business district is
Division
restricted
bench
to that.
order.
In that event, let me give us some time because I will produce another judgment is there. So in respect of a curtailment.
You understand?
I am not on the notification. I am saying that curtailment. So far as the curtailment is concerned, that cannot be treated as a grant of a new permit. That I will produce, then that will be said. Because
the statute says so, Mr. Bhutan.
there are judgment I shall.
Beyond the statute is not permitted.
Since I am minded to dismiss, let the petitioner come back.
My lord.
Instructions submitted on behalf of the state respondents is taken on record. Paragraph. Learned counsel for the petitioner seeks accommodation to take further instructions in this matter. Paragraph, let the matter appear under the same head on 20th March.
20th.
Sorry, 20th March.
Do you know?
অসুবিধা আছে?
1st of April করে দেয়। অসুবিধা হবে? 20th March.
Hearing.
February.
You want to come back in April?
No.
আমি আছি।
My lord, I beg my lord's indulgence, my lord. I had item 817, lordship. I mentioned it yesterday. My lord,
Sir, what is happening?
lordship had said that it would be taken up today, my lord. The only reason I'm troubling my lordship time and again is because it concerns the installation of all mobile towers throughout the state of West Bengal. This entire issue is in a state of flux, lordship. Which is why lordship, we need some urgent interim order.
I'm
And
prepared
Mr.
today, my lord, my lord. If my lord wants, we can start today. It's very interesting point, my lord. But
I'm led by Mr. Abhijit Mitra, but I have the liberty to start.
Lordship, I appear for the Union of India, Lordship.
Because not called. Two more matters. Bad luck, sir. Can't help what to do.
My lord, some priority be given, my lord, tomorrow, lordship. It'll take 10-15 minutes. My lord, some 10-15 minutes, not more than that. But 3 minutes only.
First matter tomorrow.
Grateful, lordship.
My lord,
Grateful,
grateful.
lordship. Grateful, grateful. Much obliged, my lord.
7 motion, first matter.
870.
817.
It's a very interesting point, my lord. We do not come across such interesting point, my lord. That's why I am also eager to.
Let us go.
My lord, I really apologize, my lord, for troubling my lord. Grateful.
So I am for the petitioner, my lord. She will remember this is a matter.
We continued, my lord. The other matter may be delayed, my lord. On last occasion, my learned friend completed his submission. I have started my submission. And my lord, in the meantime, my lord, due to my lord,
Probably, my lord, I will at least for my satisfaction, my lord, I have to refresh my memory.
my lord,
So that at least
I think, my lord, then my lord, matter will never complete. So, my lord, kindly allow me to complete my argument.
facts.
Other matters. You will take some time, isn't it?
Next, my lord, one matter and next matter is also mine, my lord.
Probably my learned friend is both concerned about the next matters, my lord. I am concerned with the present matter.
As because your lordship is asking me for this reason, I have submitted.
This matter take time.
Yes, because
I'll release
I
the
tell.
matters in that case for the day.
Yes, it will take
Yes.
time. It will take time because my lord, on the previous occasion, lordship, I have placed this case in elaborate detail, my lord,
Yes, yes.
for a lordship's convenience, my lord.
Take an elaborate notes.
So,
of
my
We have a
lord,
note
kindly
also.
allow me to
And
complete
you
my.
completed your submission on the earlier date.
Yes.
The
Earlier,
railways have made their submission.
railway have not yet
Submitting.
completed their submissions.
So let them,
So,
let
let
Mr.
them-
Joshi-
yes.
I will have a right of reply, my lord, in that
Yes,
case.
yes. Always. My lord, next matter, I think, my lord.
petition in the next matter.
Yes. ওটা ধরবে আমার মনে হয় অতক্ষণ লাগবে না
আমি চালাবো।
Next matter, please wait. Let me see. They do not take much time. We can start. Only the next matter.
Shall I?
And my lord, kindly come.
দর্শক মনে আছে?
কাল আরে মনে তুমি করিয়ে দেবে Come to the page 23, my lord.
Of the paper book.
Paper. আর কোনদিন শেষ হবে না হবে।
Page 23.
Page 23, my lord. Yes. That is the prayer of the writ petition, man.
Yes. Yes.
My lord, the prayer B, my lord, that and a writ in the nature of mandamus to issue upon the respondent authority, thereby directing them to carry out the weighment of MT 23 tons of VP number such and such. Once it comes back in the Howrah with the said train number such and such, Kamrup Express from Dibrugarh at the same route in trip parcel van for ascertaining its correct weighment upon the payment of usual charges. My lord, thereafter, my lord, this honorable court was pleased to direct, and according in compliance the direction of this honorable court, that was done, and it was found, my lord, that the lesser weight. So, my lord, I'm coming on the next point, my lord.
Yes.
The writ in the nature of mandamus to issue, thereby directing the respondent authority to take necessary steps in rectifying the motion way bridge situated at the Howrah, which is defective.
That was also completed. So, my lord, prayer B and C has been complied. Then, my lord, a writ in the nature of mandamus to issue, thereby directing the respondent authority to refund the punitive amount deposited with the railways to the tune of rupees 1,11,745 if it is found that the tier weight of VP number such and such exceeds the declared weight. So, my lord, after that, after weighment of the tier weighment of that particular, my lord, that wagon, it was found that 30.70. But, my lord, it was recorded in 32 tons. So, my lord, now the petitioner have to pay 1.30 tons excess weight, my lord. Although, my lord, railway has not charged that, but that was his liability, my lord. Then your lordship kindly come to the next page. Page 51, my lord.
Yes, you've referred to this.
Page 51.
Yes.
My lord, kindly see that is the manifest. That is to be declared by the petitioner himself, according to the section 64 of the Railway Act. Your lordship kindly come to the date at the top. Your lordship got the column number 10, date of issue of MR. Next, my lord, the column number 12, date of loading. Date of loading, my lord, 19th of November 2019. So, date of occurrence, 19th of November. And what was the weight? Their declaration, my lord, that is the, my lord, the left-hand side bottom, my lord. That is the 17,600 kgs. Then your lordship kindly come the next page 53. That is the letter dated, my lord, 19th of November 2019. At the top right-hand side, my lord, kindly see the body of the letter. Dear sir, in reference to the above subject matter, we have loaded 20 metric ton. My lord, that means, my lord, 20,000 kg. Is above VHP number such and such. But as per the railway at Howrah station, showing 25,100 kg, which is not acceptable to us. My lord, kindly consider that. In the manifesto, their own declaration, page 51, 17,600 kg. Now they are saying their own letter, 20 metric ton. My lord, that means the 20,000 kg. And railway found, my lord, 25,100. And after payment of that charges, my lord, they have taken back the goods. So at present, my lord, it is not possible for overweight, whatever may be the overweight or lesser weight. As soon as, my lord, they have paid the amount and taken back the goods, that means, my lord, they have admitted that. For this reason, they have paid the penalty, whatever may be the amount charges, that is 1,11,000 and odd. Then, my lord, kindly come to the next page, 55, my lord.
You've stated these on the earlier
Yes,
petition.
yes,
I've taken
yes,
a note of it.
yes. My lord, the railway charges that amount, my lord, 1,11,000, and they have paid, my lord.
Yes.
After payment, my lord, they have taken back the goods, my lord. And, my lord, one point was raised by my learned friend, that there was a defect in the way bridge. For this reason, railway himself, my lord, applied, one application is filed before this honorable court for rectification of that. My lord, kindly consider in my case, the overweighment was detected on 19th of November. That is page 51, my lord, from the manifesto. Your lordship, kindly come to the relevant portion of this, my application, page 75
Of your
of this paper book.
75.
Page 7. I am, my lord, my entire submission on the basis of paper.
Right. Yes.
My lord, paper book, kindly see that is a letter, my lord, first paragraph. In reference to the above, we undersigned have jointly attended Howrah Goods in Motion Way Bridge at 12 hours on 12th of December 2019 to witness the tier weighment of empty VP number such and such, and found that the said way bridge is out of order since 9.53 hours 20
23rd 11/2019 during the weighment of one loaded VP such and such. Howrah holder name such national carrying on weighment so 0 with. What happened? For the compliance of this honorable court order for taking the TR weighment of that organ, at that time it was found that weighbridge is not functioning properly. That according to that machine, that if weighbridge is not functioning properly, in that case, they always, show the weight 0. For this reason, as because the matter is pending before this honorable court, for this reason, the railway filed one application for rectification of this weighbridge, as because, that repairing maintenance, that is the liability of the state government. That is the legal methodology department. And they have also subsequently, they have also added party, for this reason, railway filed this application. It is not that the since from 19th November, the machine was not functioning. After almost 1 month, on particular on that day, that was detected, at that time, And then your lordship kindly come to the next page, 114,
Yes.
114, That is a letter dated 13 January 2020 to the Assistant Controller of Legal Methodology, and it was written by the Railway Authority. As such, as per directive of Honorable High Court, Calcutta, dated 26 November 2019 and 17 December 2019, TR weighment of MTVP number such and such to be done on at 14 hours in presence of the representative or your and the petitioner. It is therefore requested to send your officials on 13 January 2020 and 12 at 14 hours to witness the TR weighment of the subject VP Unmotion Weighbridge, Howrah, for compliance of the Honorable Court order. And my lord, kindly see that copy to the order, 1 national carrying, and my lord, the learned advocate's name, my lord, serial number 5. So everybody was, my lord, the notice was given, and they were also present, my lord. Kindly come to the next page. Yeah, petitioner was also present. 115, my lord. Witness of the TR weighment of parcel number such and such in Unmotion Weighbridge, Howrah Station on 13 January 2020 at for 16:20 hours as per the order of the Honorable High Court, Calcutta, in court order number such and such, National Carrying Corporation versus Union of India. My lord, date of the letter 13 January 2020, according to the notice, my lord. In reference to the above, we the undersigned have jointly attended Howrah goods in Unmotion Weighbridge on 16 hours on 13 January 2020 to witness the TR weighment of MTVP number such and such and observe the following. MTVP number such and such has been weighted at the electronics in motion weighbridge and found 30.70 tons. But my lord, the recorded weighment 32 tons. So my lord, the more excess overweighment is 1.30 tons. And my lord, kindly see the everybody was signed, and the petitioner representative was also, my lord, at the bottom, my lord, left hand side, right hand side, representative of Messrs. National Carrying Corporation. My lord, so in presence of the various authorities of the railway as well as the legal meteorological department and the petitioner, that was found that 30.70 tons. But my lord, the TR weighment, that was, my lord, 32 tons, my lord. So, my lord, kindly consider that the excess was, what was the, according to their manifesto, they have their own declaration, 17,600, page 51. So, my lord, 17.60 tons, their own declaration.
Mr. Ghosh, one thing, the railway has no reciprocal responsibility at the point of initiation to check the goods, according to the circular.
No, my lord.
The petitioner says it is 17,600.
Yes.
So corresponding,
Yes,
the railway
yes.
has no
For
responsibility.
this reason, my lord, that was, for this reason, my lord, that was found
25,600. My lord,
At the time of loading.
no, my lord, what happened, my lord, at the time of loading, my lord, in every station, e-motion web bridge is not, my lord, available. This is the main problem. And my lord, according to the section 64 and 65 of the Railway Board, Railway Acts, my lord, the before taking the delivery, railway from the time of delivery, and my lord, at the point of before taking the delivery, railway can reoit, my lord. And at the time of reoitment, my lord, it was found that overoitment.
No, I think
So
my lord,
railway
this
has
is
the
under
definitely, my lord, your lordship is rightly pointed out the
Mr. Nayak,
railway.
you can help me.
Yes, I am helping.
Problem
My
at
lord,
the time of loading.
yes, yes.
The railway
At that,
also.
there are two provisions, my lord. আমাকে বলে নিতে দাও, তারপর বলবো।
I just want to see the provision.
My lord, kindly see the provision 64, my lord.
At page?
64 of the Railway Act. It is also.
Circular.
Yes, circular. 64 of the Railway Act, man. Yes, sir. Circular is there. Yes, this is the circular, my lord. Kindly pardon me, my lord. This is a circular. Lordship, this is 64, my lord. Kindly that is the forwarding note. That is the manifesto, my lord. And lordship, kindly read along with this page 40 of the agreement. Absolutely, it has been cleared.
Yes, this is your circular.
Now, I'm coming. That is, my lord, circular, and my lord, I'm placing, my lord, I'm coming on that point, my lord. Kindly consider the section 64 and 65 of the Railway Act, my lord. What the Act says. Excellent. Lordship, kindly come to page 40 for once. It will clear. I read.
Next, when you get a chance to reply.
Okay,
not
okay.
now. I just wanted to, because it was somewhere in
Yes.
the find that there is a circular. What circular is this?
The commercial manual.
Please give me a copy of this.
Yes, the copy is here, ma'am. আমাকে একটু দেবে? হ্যাঁ, definitely.
Yes, section 64.
Section 64. কোনটা দেখালে? তুমি যেটা পড়বে সেটারই clarification আছে। My lord, section 64, my lord.
Yes.
Forwarding note. My lord, that forwarding note manifesto same thing, man. Section 1, my lord. Every person entrusting any goods to a railway administration for carriage shall execute a forwarding note in such a form as may be prescribed by the central government, provided that no such forwarding note shall be executed in case of such goods as may be prescribed. 2. The consignor shall be responsible for correctness of the particulars furnished by him in the forwarding note. The consignor shall indemnify the railway administration against any damage suffered by it by reasons of the incorrectness or incompleteness of the particulars in the forwarding note. My lord, so my lord, according to the section 64, they voluntarily submitted the manifesto declaring the weight. That was 17,100 kgs. And my lord, kindly then come to the section 65, my lord. A railway administration shall, my lord, this is the responsibility of the railway. In a case where the goods are to be loaded by a person entrusting such goods on the completion of such loading, or in any other case on the acceptance of the goods by it, issue a railway receipt in such form as may be prescribed by the central government. 2. A railway receipt shall be a prima facie evidence of the weight and the number of the packages stated therein, provided that in case of a consignment in wagon load or train load, and the weight or numbers of the packages is not checked by the railway servant authorized in this behalf, and a statement on to that effect is recorded in such railway receipt by him, the burden of providing the weight, or as the case may be, the number of the packages stated therein shall lie on the consignor, the consignee or engrossee. So, my lord, when the railway, my lord, reweighted or my lord weighted, my lord, it was found overweighment.
Despite which it was loaded.
My lord, initially when the consignment was loaded, according to the declaration of the petitioner himself.
But there was a reciprocal duty of the railways
Yes.
also.
And thereafter,
Has that been performed by the railways?
yes, my lord, for this is my lord, railway weighted that and it was found that overweighment.
When the railway weighed the when was the weight?
My lord, before taking the delivery.
Where is that? Please show me the document. That it was weighed before taking delivery.
Yes. My lord, kindly come to the paragraph 5 of the writ petition, that is page 9 of the paper book.
Yes.
My lord, the petitioner states that in the usual course of business on November 18, 2019, the yes,
Paragraph?
paragraph 5. Paragraph 5 of page 9, my lord.
Paragraph
That is the paragraph 5 of the writ petition, my lord.
Yes, yes.
The petitioner states that in the usual course of business on November 18, 2019, the petitioner number 1, upon paying the advance freight charges for loading of parcel van against the valid money receipt dated 18 November 2019, had loaded goods parcel weighing about 17,600 kilograms in the said 23 tons VHP bearing attached to the train number such and such. It may be noted that in this connection that upon completion of the said loading, a railway manifest duly countersigned by the Chief Parcel Supervisor, Eastern Railway, was prepared. My lord, the railway manifest, that is the section 64, that is the entire responsibility of the petitioner. Voluntarily, they have submitted that. Taking that, my lord, that weight was correct, that is 7,600. And after reweighment, it was found excess weighment. Then, my lord, kindly come to the next paragraph. The petitioner stated that the said train was scheduled to be depart from Howrah on November 19, 2019, and prior to its departure from the Howrah station, the railway conducted an in-motion weighment of the said parcel van without notice to the petitioner number 1 and or its representative on 19/11/2019 and found the said parcel van to be overloaded by 2.10 ton. Upon such weighment, the representative of the petitioner number was informed by the Eastern Railway Authority. However, no weighment slip was handed over to the said representative of the petitioner number 1. The said parcel van containing the goods of the petitioner number 1, including life-saving drugs, was detected detached from the train and kept in the same station in sealed condition. The petitioner number 1 was not permitted to unload the same.
So kindly mark this paragraph. It's a very vital paragraph because this paragraph will clear their arbitrariness. I will demonstrate.
So, my lord, their voluntarily declaration 17,100 kgs. And at the time of weighment, it was found overweighment. Next paragraph. The petitioner stated that under the aforesaid circumstances, the petitioner on the same day made a representation before the respondent number 5 herein, thereby indicating their objection as to the reading of the in-motion weighting scale at Howrah and also with regard to the tier and freight for reweighment of the said parcel van and also for the empty parcel van. The petitioner states that despite receipt of the said representation, the respondent authority has not taken any steps to conduct the reweighment of the said VP number such and such. So, my lord, there in the Railway Act, my lord, there is no such provision for, my lord, reweighment of that VP, my lord, empty VP. My lord, kindly see the section 79, my lord.
my lord, before that, my lord, kindly come to the page 78, my lord.
I'll release the next matter also, and this will take time. Since, madam, you are waiting unnecessarily. Yes, 79.
Page, not page 79, Railway Act, section 78.
78, yes, yes.
You also got section 78. Power to measure weight, etc. Notwithstanding anything contained in the railway receipt, my lord, that is in terms of the section 65. The railway administration may, before the delivery of the consignment, have a right to remeasure, reweight, reclassify any consignment. 2. Recalculate the freight and other charges. And correct any other error or collect any amount that may have been omitted to the charge, to be charged. So, my lord, in my case, what happened? My lord, at the time of that weighment or reweighment, it was found overweighment. For this reason, railway, my lord, issued, my lord, for charges, additional charges of 1,11,745. They had paid. And after that, my lord, the delivery of the goods was taken. So, my lord, what happened? My lord, as soon as, according to the section 78, my lord, weighment was held. And my lord, they have, upon paying of the penalty or my lord, the additional freight charges, they have taken the goods. My lord, there is no such, my lord, the physically it is not possible for another reweighment, as because the goods was taken back by the petitioner himself. And my lord, kindly see the next page 79. 79 says provision is for reweighment.
Yes.
My lord, there is reweighment of the consignment. Reweighment, not for the reweighment of the empty, my lord, the parcel van. And my lord, certainly, my lord, my learned, from the petitioner side, that point would be raised. My lord, at the time of weighment, and at the no representative was there. So, according to the Railway Act also, my lord, there is no such provision for presence of the petitioner side. And my lord, the exactly on a decision of our honorable division bench, my lord, it was stated, my lord, their presence is also not necessary, my lord. Yes, sir. My lord, kindly see that judgment, my lord. My lord, it is the judgment of the division bench of the Honorable Justice Sanjeev Banerjee and Kaushik Chandra, my lord. Kindly see that the appellant apparently transported fly ash from Dibrugarh on February 2017. The matter pertains to penalty and charges for overloading the rake as imposed by the railways. The appellant writ petitioner relies on the weights of the wagon obtained at the NTPC weighbridge at Thalagaon and says that the railway receipts were obtained by disclosing such weights after having the wagons weighted at the NTPC weighbridge. According to the appellant, en route at Deogaru, weighment was conducted as sacrilegally, and in course of such reweighment, the railways purportedly discovered the weights of the wagon to be much in excess of what was declared by the appellant as the consignor, and as a consequence, additional charges were demanded and penalty imposed. And exactly like my case, my lord. The appellant says that the appellant made the appellant says that the appellant made a payment as demanded under the protest to obtain the delivery of the goods covered by the railway receipt. But the appellant did not make any demand for reweighment of the wagon at the destination station or any other places. Section 64 of the Railway Act 1989 of a consignor of the goods on the railway declaring the weight of the goods and the railway receives to carry such weight. Section 78 of the Act permits inter alia reweighment of the goods at any time. Sometimes reweighment is carried out in motion if there is a weighbridge en route to the destination station, and it may not always be possible to inform the consignor or consignee for their representative to be present at the time of such reweighment. However, Section 79 of the Act permits a consignee or any person interested in the goods to protest the demand for payment of additional charges and penalty as may have been made under Section 73 of the Act. Once such a protest is made, the consignee or the person interested in the goods has to be demand a reweighment. Damage and other charges can be levied in that event. Upon the reweighment, the figure cited by the railway comes out to be correct, and initial figure submitted by the consignor turns out to be incorrect. Even the right under Section 79 of the Act is not absolute, in the sense that the right to seek reweighment depends on the matters of public interest, since a particular station may be too congested or a weighbridge may not be available. However, without any reweighment being sought, there is a little scope for challenge the demand made by the railways for additional weight or overweight, or for penalty or like as in the present case. It must be appreciated that difficulties arises since the goods are carried on trucks and it is difficult to obtain weighbridge on trucks. In the present case, there is no doubt that the appellant herein or the consignee or the other person interested in the goods protested the additional demand made by the railway, but there was no simultaneous request for the reweighment. In such a scenario, without there being any further reweighment, the appellant cannot demonstrate that the weight recorded by the railways during in-motion weighbridge was wrong. In the light of the award, the writ petition has been appropriately dismissed by the writ court, and the judgment and order dated September do not call for any interference. So, my lord, that this honorable court's observation, division bench observation, that the Section 79 right for reweighment, it is not also absolute. And my lord, in my case, what happens? My lord, if the goods is taken by the petitioner, then how it is possible? So practically it is not possible. And my lord, the other prayer B and C, in compliance of this honorable court order, that is, my lord, the empty rake DP wagon, my lord, for actually, my lord, Section 79, there is no such provision for weighment of the empty rake, my lord. Provision for reweighment of the consignment. For this reason, my lord, in compliance of this honorable court, railway, my lord, that was done, my lord. And my lord, another decision. My lord, that judgment was also subsequently affirmed by the division bench. My lord, in my case, my lord, there is a serious disputed question of facts is involved, my lord. And my lord, matter is entirely related to the freight charges or additional freight charges. My lord, kindly see the page 16, second paragraph.
Yes.
It appears to me that the issue involved in the said case with regard to the reoidment under section 78, but here the issue is demand based on alleged false declaration about the purpose of use of consignment in question, and as such, the fact and the issue of the said case is different from the present one and is not applicable to this case.
This is a different situation altogether.
My lord, particularly issue was framed.
What's the purpose of the use of consignment in question?
Yes, my lord. My lord, kindly come to the next paragraph. Considering the facts appear on perusal of the relevant records available, submission on the parties and decision relied upon by the parties, the issue arises for consideration in this writ petition, according to me, are hereunder. Whether impugned order raising the demand in question with the reasons passed by the respondent railway authorities concerned in compliance of the earlier order dated such and such, in case of the writ petitioner, is without jurisdiction. 2. Whether the writ court itself can determine the freight rate on the consignment in question as per relevant circulars. Whether the writ court can decide the issue of fallacy or truthfulness of a declaration made by the parties with regard to the consignment in the question, and whether it was for domestic purpose or for export purpose, which is the determining factor of a rate of weight, and whether the railway has the jurisdiction to recover under the charges if discovered after the delivery of the consignment. Whether in view of section 33, 36, 38 and 44 of the Railways Act 1989, tribunal is the appropriate forum for adjudication of the nature of the dispute involved and the relief claim in the instant writ petition. Considering the facts and circumstances of the case, perusal of the relevant record, submission of the parties and the relevant provision of the law and judgment cited by the parties, my answer of the aforesaid issues as hereunder. 1. In view of the order passed by this court dated 14 February 2011, in earlier writ petition filed by the petitioners herein, given liberty to the respondents, it cannot be said that the impugned demand notice with recorded reasons are without jurisdiction. Writ court is not an appropriate forum to determine the rate of freight on a consignment, and there is no specific bar under the Railways Act 1989.
Not applicable to this case at all.
Yes, my lord. Particularly the issue number 4, my lord. Jurisdiction point. I am coming, my lord. Recovery to evaded under charges freight if detected after delivery of the consignment in facts and circumstances of the case. Writ court is not the appropriate forum to adjudicate the disputed question of fact. Absolutely fallacy or truthfulness of a declaration made by the parties about the consignment in question, and to inquire about the use of the same as to whether it was used for the domestic purpose or for the purpose of export. Taking into consideration the facts and circumstances involved in the case, and after considering the relevant provision of section 33, 36, 38 and 44 of the Railways Act 1989, which were not considered at the stage of admission of this writ petition, I am of the considered view that the tribunal is the appropriate forum for adjudication of the nature and dispute involved and relief claimed by the petitioner in the instant writ petition. In the view of the above discussion, I am not inclined to give any relief to the petitioner in this writ petition. However, liberty is granted to the petitioners to approach the tribunal against the impugned orders of demand in question within 6 weeks from the date, and if the petitioners file appropriate application before the tribunal within the stipulated time, it will not raise the question of limitation, considering the facts that in this writ petition interim order dated such and such, respondent were restrained from taking steps for recovery of the demand in question, and the same shall be continued for a period of 8 weeks from the date. Petitioner are also liberty to make appropriate application before the tribunal for interim protection. Tribunal shall make all the efforts to conclude and pass final order within 6 months from the date of filing such application. My lord, challenging that order, my lord, they went before the division bench, but the division bench, my lord, prima facie accepted this order of this single bench, and my lord, thereafter, my lord, instead of preferring, my lord, the tribunal, they have paid the penalty, whichever made the charges, and thereafter when they have taken back the consignment. So, my lord, in my case also, my lord, there is a disputed question of fact is involved regarding the weight. So, my lord, my humble and respectful submission, this judgment of this Honorable Settlement, Honorable Justice Muhammad Nizamuddin is also applicable in my case also, my lord. So, accordingly, my lord, this writ petition is not maintainable here. So, my lord, they have another forum, my lord. Initially, that forum was, my lord, the Railway Rates Tribunal. But, my lord, all over India, that only one forum is there. For this reason, my lord, 2017, the Railway Act was amended, and, my lord, the Railway Claims Tribunal has given the power, my lord. And in Calcutta, my lord, the Railway Claims Tribunal is also grateful.
So before dealing with this submission of my
And,
learned
my lord,
friend,
it is expected, my lord, my learned friend will reply in respect of, my lord, the law points, my lord.
exactly on the basis of law points. The first judgment, my lord, which has been handed over to your lordship,
Yes.
the MAT 1418 of 2018.
Yes.
Lordship, I am distinguishing right now. Kindly come to the first page, the paragraph, bottom paragraph, third paragraph.
Yes.
The appellant says that the appellant made the payment as demanded under protest to obtain delivery of the goods covered by the railway receipts. But the appellant did not make any demand for repayment. So, my lord, what in that case happened, there was a demand that you have to pay this much. They paid the amount under protest and came afterward to challenge that the freight. But they have not challenged they have not made any prayer for repayment. That first they have to challenge the process. Here I have challenged the process. My prayer for repayment is there at page 53. But here, without making any prayer for repayment, they have come directly to challenge the excess freight which has been charged by the railways. So the basis has to be there by challenging the process of excess freight. This is the basic difference, my lord. And also in the second page, my lord, in the present case, there is no doubt that the appellant herein or the consignee, second page, last paragraph. In the present case, there is no doubt that the appellant herein or the consignee or the person interested in the goods protested the additional demand made by the railways, but there was no simultaneous request for repayment. Here I have prayed for repayment, and my prayer, as my learned friend lordship has taken a lordship through, it's clear that I have made a prayer for repayment, and I have also paid the punitive demand under protest, and I approached this honorable court with the prayer that this has to be done. Lordship, the honorable court has acceded to the prayer of the petitioner and directed them to do the following things. Now, my lord, the second judgment which has been placed before your lordship, I am not challenging the rates. My lord, the applicability of rates is not under challenge before your lordship. That the railway has applied this rate, ought to have applied that rate. If I have challenged that, then I ought to have, lordship, gone to the tribunal, Railway Rates Tribunal. Whatever they have demanded, I have paid on protest, and I have sought repayment prior to that. I am not challenging the rates. This is the basic difference. So this judgment is also not applicable. It's on a different footing. Now, my lord, so far as my learned friend has said that I have stated one thing at one in the representation and another aspect in the manifest. May I? This is my humble submission, my lord. Kindly see what I have stated in the manifest. It is at page 51. Kindly see 17,600 kilos. Now, lordship, kindly come to paragraph 5. Paragraph 5, my lord, of the writ petition, page 4. Lordship will found 17,600 kilos. It's on oath. It's on oath, my lord. So, I have what my learned friend has said that I have stated different thing, my lord, in the representation for repayment at page 53, my lord, my learned friend has taken your lordship saying that I have said 20 metric ton. So, my lord, may I putting this question to myself that there is no charge of misdeclaration against me. Because at the time of loading of the consignment, whatever I have loaded, that is 17,600 kilo, I have placed before the railways. Had I stated different thing at that material point of time, my lord, then Lordship kindly come, there is a specific charge at page 45. What is the, Lordship kindly mark this, clause 27.22. If the information declaration made by the leaseholder is found false at any stage before or after awarding the contract or deliberately defrauds with the railways, his or her their registration will be cancelled and registration fee will be forfeited. In addition to forfeiture of registration fee, all his or existing leasing contracts being operated from that division would be cancelled. So at the time of loading and at the time of preparation of the manifest, the weight which I have declared, my lord, is there with the railways. And also in this, before this honorable court, I have stated on oath that I have loaded 17,600 kilos. Lordship, there were some printing mistakes, may I say this thing, in the representation. Lordship, kindly go by that, because had I misdeclared, my registration would have been cancelled. It would have attracted clause 27.22, which they have not done against me. And so far as the Lordship, the notice of payment is concerned, Lordship has already seen this manual which I have placed, that it has to be done in front of the railways. And in addition to that, Lordship, kindly come to page 40. It will clear everything. Page 40. 20.7. This is the agreement, my lord. This is a relevant clause, page 40, clause 20.7. May I read, my lord? Effort should be made to conduct payment in presence of the concerned leaseholder or his, her, their representative. The report of payment result should be countersigned by the CPS. The party concerned will also countersign on the relevant record. So the manual says, my lord, it has to be done in presence of the railways, and only upon finding the weight to be correct and within the permissible limit, then they will allow it to get it dispatched. Now that has to be done with clause 20.7, because it's in the originating station, my lord. Whatever I say is not sacrosanct. I understand, my lord. Then that has to be verified from the railways end through this process. So they have not intimated me whether they have carried the payment or not. They have not taken countersign of mine. That is the reason paragraph 6 I was telling, my lord. I am grateful to my learned friend that my learned friend has highlighted paragraph 6, which says, my lord, kindly look page 5.
Yes.
I'm reading once again. The petitioner states that the said train was scheduled to depart from Howrah on November 19, 2019, and prior to its departure from Howrah station, the railways conducted an in-motion payment of the said parcel van without notice to the petitioner number 1 and or its representative on 19/11/2019, and found the said parcel van to be overloaded by 2.10 ton. Upon such payment, the representative of the petitioner number was informed by the Eastern Railway after that exercise was undertaken unilaterally against the provision of the rules. However, no payment slip was handed over to the representative of the petition number. It has to have my own signature as per clause 20.7. This was not done. So illegality starts from that. And now, my lord, another aspect. They have said that the defect was only on the particular date when the payment was carried on in the in-motion weighbridge. Now, my lord, kindly come to Railway's own submission, which they have made on which is appearing at page 61, first order of this Honorable High Court. What they have stated before this Honorable High Court. I will not going to take much time. If you kindly come to page 63, the internal.
Yes.
Mr. Ghosh, page 63, internal page 3. Mr. Ghosh also relies upon a purported certificate of the Controller of Legal Metrology dated 27 July 2019, certifying that the in-motion way bridge at Howrah Station goods yard is correctly functioned. So Lordship is aware of this fact that any certificate from the legal metrology, now kindly see the date, 27 July 2019, has a validity of 1 year. That yes, we have checked it, it will be fine and function. But the same authority, my lord, has neglected, may I say this thing, that railways have made an application before this honorable court upon finding that their sole in-motion way bridge is defective, with a prayer upon the legal metrology to rectify the defects. So, the certificate by the legal metrology, as relied by my learned friend, was in effect was not correct. Kindly see the prayer portion. The railways application starts from page 75. Kindly see what they have prayed. It is at page 80.
Yes.
The applicant therefore humbly prays, my lord, that your lordships may graciously be pleased to direct upon the concerned authority of the added respondent number 7, that is the Controller Legal Metrology, Government West Bengal, Ganesh Chandra, to take appropriate steps for repairing of the said electronic in-motion way bridge at Howrah Station by giving permission for opening the seals provided on console unit and junction box. So it was not functioning. At one hand, they are producing the certificate saying that it is valid for 1 year. And another hand, they are making application before this honorable court in my writ petition, praying for rectification and repairing. So on
2020.
Yes, because it was not functioning. My prayer, as my learned friend has read, my lord, before this honorable court, was very specific. For rectification of the defect of the in-motion way bridge and payment of the tear, there are two aspects. In-motion way bridge was not at all function, and it is not I am saying, it is railway's own assertion. And the tear weight, my lord, what my learned friend has said is 30.70 ton. So my lord, may I say one thing? 32 ton, as my learned friend has said, is the weight should be of the tear weight.
Yes.
So 32 ton has to be read with 23 tons. If the weight gets reduced by 30.70 ton, automatically 23 tons will also get reduced to 1.30 ton, because there has to be some proximity. 32 tons means 23 tons. If 30.70 is the actual weight, then permissible carrying capacity also get lesser. It's directly proportional. It's directly, my lord, it will get lesser. Because
Not necessarily, Mr. Rao.
may I say one thing, my lord? This pen has is a 32 ton capacity. I can put 23 ton parcel space. One segment. If the overall weight gets reduced by 30.70,
Capacity may not reduce.
but it has 30.70. It's dangerous. This is the weight of the tear. Empty wagon.
That doesn't necessarily mean that the capacity will reduce.
The capacity has to have some direct nexus with the total weight of the.
Then I'll be
My lord, it's already 4:30, my lord.
need some more time.
আর বলবো কিছু তুমি?
আমার তো আরো কিছু বলার ছিল। যাই হোক, I will not disturb your lordship right now. But you can finally fix any date. I will conclude my submission within 10
মানে
minutes.
আবার ডেট চাই তোমার?
Now, my lord, I will not say anything further. Only I will, lordship, placed two judgments of the honorable single bench and the division bench. This issue is settled. Only the adverse inference has been drawn that if it is found that the in-motion way bridge is not properly functional, coordinate bench judgment of Justice Bhattacharya is operating in the field. Punitive demand was directed to be refunded, and that has been affirmed by the honorable division bench. Lordship, kindly see these judgments.
Do you have further submissions to make? I can give you time, little time on.
Probably, my lord, I will not.
No.
No, I would have placed those judgments, but these judgments
You
are.
have to place them.
I have already placed those judgments squarely applicable in this case because defect was exposed. And it was directed that punitive demand has to be refunded. And that has also been taken care of by the division bench.
You've given the judgment.
Yes,
already.
this judgment again I am handing over.
এই নামটা বলো তো এটা কি?
তোমার কাছেও আছে এক্ষুনি দেখলাম তো এই।
That's all.
That is all my submission. Only I am praying, my lord, this judgment which has been highlighted by the honorable has
Just
not
take
no
it.
relevancy.
You've just submitted.
Yes, yes, has no relevance.
Concluded, judgment reserved. You can take back this manual, the entire thing.
Grateful, my lord has
Sir.
given a patient hearing.
That's my duty.